Yes.
Adjournment request, if any, from item number 1 to 6. From item number 7 to 17.
Maybe the lordship.
Yes.
I beg to mention item number 9, my lord.
9.
Yes, my lord. Matter we adjourn for the day, my lord. My,
Item number 9 is only for condonation delay.
except my senior Mr. Wadal is out of station. And he has instructed me to.
Is it coming for the first time?
Yes, my lord. I've taken the
We'll
others.
issue notice, don't worry. Your senior will be happy. And maybe if the other respondents are here, we may condone the delay. Don't worry.
May I please, your lordship. First, I beg to mention item number 15, lordship.
1-5.
1-5, lordship. The leading counsel is not in position to appear today, lordship.
PIL matters, we'll see. No, we are not very hesitant to grant time, but we'll see. Let's see. The other side has to be here. You have flagged the issue, we will see.
Lordship.
If we have to pass any order, we have to close the petition, we might wait for your senior. If we don't have to close the petition, why take time?
Lordship.
All right. Yes.
Item 18 to 29. Adjournment request.
May it please, your lordships. Your lordships, with the consent of the parties, I beg to mention item number 28.
28.
Lordship. Lordship, this matter may be listed after vacation.
And that's all right, but you have taken consent from whom?
Lordship, from the petitioner as well as the private respondent.
And who are you?
Lordship, I am appearing for BDC, Lordship, on behalf of Mr. A.K. Bhaiya.
A prayer for adjournment after seeking consent of the council for all the parties has been made on behalf of the council representing the Bodoland Territorial Council. Let this matter come up for consideration sometimes in February.
Wait, please, your lordship.
11 February.
Item 18, lordship, on the last token, directed to file my affidavit, which I have filed on fee, but it is not there. May
We
it be
will
called for
have it summoned.
lordship.
Umang Valam.
Yeah.
Yes.
From item number 35 to 37. Adjournment request. No. Daily list for this item 1.
May it please, Lordship. I'm sorry, Lordship, we are supposed to file an affidavit, which was not filed. Lordship, we have got the up-to-date information and things are progressing in the right direction. In fact, in 2023, one direction was passed by this honorable court
Yes.
with a specific 12 number of instructions for which state government is proceeding. LOS has been issued and substantially it has been complied also. Few final act has to be done,
All right.
basically
So
regarding the promotion of the.
We grant you time. You put it on oath. You put it on oath. Whatever steps you have taken,
Lordship.
put it there. Sometimes January and February.
January of February 1st week, Lordship.
My lord, there is another aspect, my lord. There was also an order to give the demarcation of the Ramsar site,
Yes.
and that affidavit is not coming, my lord. Regarding the that is the order dated 27/5/24, my lord.
We have we done something?
27/5/24. and there-
22. All right. In that affidavit, you
That affidavit, my learned friend has filed already.
my lord, that was regarding the high floodplain. and
just
low-
whatever
the
issues are
demarcation
flagged,
of
Lordship.
please.
We'll do
accept-
that, Lordship.
The learned advocate general submits that the affidavit, the directions of this court are being continuously complied with, and the steps taken up till now shall be put on record by the next date. Re-notify this case on February 1st week.
4th of February.
Deeply of this.
4-2.
This is with respect to Dipor bill.
Before
Yes,
bill,
ma'am.
Lordship.
Ramsar site.
Item number 2.
Nobody appears. Nobody appears on behalf of the petitioner. On behalf of the appellant applicant, re-notify. Appellant hai ya WA? Nobody appears on behalf of the appellant applicant. List this matter on. Give a date in January.
5-1. 5th January. Item 3.
Lordship, in this matter, Lordship, I need given Lordship 1 week more time to file the additional affidavit, Lordship.
No, but who appears for the other side? All respondents have been served.
Lordship, I am for respondent, Lordship.
Let counsel for the appellant applicant seek some more time to put in additional affidavit in the matter. Let this application, along with the appeal, let this application, let this application come up for consideration on some date in January.
Apply.
30th January 30.
ये अपील है ना
Item 4,
ये क्या नाम है इनका इनका क्या नाम है
Nobel Prize type है 4 and 5.
4 and 5.
Reference is already on record.
My,
Reference is there.
my,
We will have it listed along with the reference
right.
after admitting it.
Then paper book may also.
Yes. Take down this appeal is admitted for hearing. Let the registry process the preparation of paper book expeditiously. List this appeal along with the death reference number so and so,
Right.
which is slated to be listed on. Together,
Reference part, reference is part.
Reference is already there.
listed on so and so date. When do you want, we will hear it?
Anytime, my lord.
January?
January.
Lord.
January after.
Only amicus curiae is to be appointed in the appeal matter.
Okay. What time do they take to prepare the paper book?
Minimum 1 and 2 months.
February, mid-February.
That will be better. Much obligement.
17th February.
Deeply obliged.
What is 6?
Item number 6,
Yeah, it's my orders.
May I pray, Lordship?
Yes,
A respondent is supposed to file their response.
they have not filed it.
They have-
No, my lord, I have received instruction, my lord, written instruction. As per my instruction, my lord, he based on the test pass certificate of his elder brother, says, my lord,
Hey, you have to put that on record, no? You have received instructions, you are talking out of your instructions, we don't know what your instructions are.
I will file affidavit.
The Land Council for the respondent seeks some more time to put in the response affidavit. Stop. Let such an affidavit be filed by the next stage, re-notify. We give you this year only,
This is
put it sometime late December. Last week. Last week of December, all right.
17th
Instructions
December.
you have received, so we will do it.
Lordship. Oblige, Lordship.
17th December.
Lord.
Item number 7,
What do you have not taken steps?
My lord, I had taken steps, but I was under the apprehension that the steps weren't taken. But I've been granted 2 days time to take steps first.
Apprehension.
Misapprehension.
I
It was
mean,
misgiven.
why misapprehension also?
Because I was informed that the steps had been taken and the respondent
your
is
name?
aware of the procedure.
What is your name?
N. Barua.
Mr. N. Barwal, and an advocate for the applicant, submits that due to some inadvertence and misunderstanding, steps for issuance of notice on respondents could not be taken. So he submits that he shall be filing the requisite cetera for issuance of notice within 2 days. Stop. If the requisites are filed within 2 days, let notice be issued to the respondent, returnable on
6th of February. 6/2.
Oblige.
Item 8,
But I appear for the respondents. I have no objection if delay is condoned.
take down, there's an application seeking, you have no objection, no?
No, let the
There's an
matter.
application seeking
Register.
condonation of delay of 150 days. After having gone through the application and having heard the land council with parties, we deem it appropriate to condone the delay as good cause has been made out. There is no effective resistance from the respondent also with respect to condonation of delay. The application stands allowed, the delay is condoned, the appeal be processed and be listed on
9th February.
फिर आप आगे करते जाओ पीछे आगे करते जाओ 9th के बाद 10th फिर सब एक जगह हो जाएगा यू हैव अ कैलेंडर Not many cases on one day, not more than 40, 35.
Item number 9.
First time.
My lord, I appear for the respondent. Delay may be condoned, but I have no objection.
Same order. Take the appearance slip off. Allowed.
11
Datta, why did you anticipate that less than 200 days, less than 300 days? we are-
I know that, my lord, that's.
All right.
11 February. Item number 10.
19.
May
All
please,
state
Your Lordship.
respondents? All state respondents?
No, Lordship, I'm for one.
One. Rest of others?
Others, industry.
So
No,
you
no, Lordship, other.
accept notice on behalf of the court. We are at 19 days delay.
Yes, others are for corporation, Lordship.
Just- Can you inform the council for,
Lordship, I see.
please inform, we are keeping it tomorrow.
Lordship, I see.
Let this matter come. Please inform, but
Lordship.
MS
Deeply obliged, Your Lordship.
unnecessarily notice will take time. We condone the delay, 19 days.
Problem.
Anyway, MS Sharma, forget it. Forget it, don't, we are condoning the delay. This is an application seeking condonation of delay of 90 days in preferring the appeal. Stop. MS Sharma, learned advocate for respondent number 1 has appeared. Sorry, MS Arvind Bora, learned advocate has appeared on behalf of respondent number 1. Despite the fact that names of the advocates appearing for names of the advocates for response number 2, 3, and 4 are shown in the cause list. There is no appearance today on their behalf. However, after having gone through the application and having heard the learned counsel for the applicant and respondent number 1, we find that good cause has been made out of condoning the delay. We order accordingly, the delay is condoned, the application stands allowed, the appeal to be processed.
Deeply obliged, Your Lordship.
Give a date. I will not dictate all these, you just take it.
Item 11 for admission.
Yes.
Lordship, my senior is late in another court. Kindly pass about the matter for the time being.
For one case, for 2 cases. Call after this case now.
Item 12.
May I please, Your Lordship, my lord? I beg
Yes,
to
Mr.
appear through VC, my lord. My lord, this pertains to illegal fishing within the Kaziranga National Park, where every year during the 13th, 14th, the Uruka, Mag Bihu, my lord, about hundreds of people enter the national park.
This issue is worth noticing.
Yes,
Now let us see what have you prayed for.
my lord. The prayers are at page 24, my lord.
Yes, please read out.
number 8 net.
Lord, it is most respectfully prayed that this honorable court may be pleased to pass appropriate writ order directions to impose a complete and immediate ban on fishing in water bodies within the Kaziranga National Park and Tiger Reserve. Pass appropriate writ directions to the respondents to comply strictly with all provisions of the Wildlife Protection Act 1972 and the Forest Conservation Act 1980 to ensure that fishing within the Kaziranga National Park and Tiger Reserve is not permitted. Pass appropriate writ orders directions to the respondents to ensure that all prohibitory and preventive orders issued from time to time by the competent authorities in Koliabar and Golaghat are enforced under the BNS 2023 and other applicable laws, and stringent action is taken against those found to be in violation of such prohibitory orders, as well as those failing to enforce such prohibitory orders. And
That's right.
and there's an interim order, my lord. Also, I have prayed at page 25. Pending disposal, it is respectfully prayed that this honorable court may be pleased to direct the respondents to ensure that no fishing is permitted within the Kaziranga National Park and Tiger Reserve.
That's your main prayer. Why enter him? We'll pass an order immediately, but
My
let them
lord.
respond.
My lords.
You please respond, Mr.
My lord, in fact, my lord will see the annexures. We have written time to time that because mob is involved.
Satisfy
My
us.
lord. We'll
What steps
respond.
have you taken? You are the state. If you have written, you
Yes,
must
yes.
pursue it with the department, no?
And my lord will see the other documents also, page
You appear
48.
in
my lord.
response number 2 and 3.
I appear for the forest department, my lords, 2,
1 is
2, 4, 5,
2,
4 and 5.
2, 4 and 5.
My lord.
Now you have written to whom?
My lord, we have written to the DC, my lord, state, my lords. Forest Department writes to the state, my lords. The state in the capacity of, my lord, is SDO and also the police, my lords,
No,
SP, my
no,
lords.
are you content with that?
My lords, we write, my lords, every time, my lords, during this is coming, my lords, 13 or 14 January, my lords.
The executive, it's part of the executive body, no?
My lords, yes, my lords, we
But
write,
you have written, so that does not
we
absolve
write,
you.
my lords, they also promulgate, my lords, 144,
Now,
of this,
Mr. Gogoi,
my lords.
we are not satisfied with your writing.
No, my lords, reacting to our, in response to that, my lords, lordship will kindly see this page 48. They promulgate, my lords. 144 orders are always issued by the
Page
authorities.
48.
48, my lords. Time to time, my lords, magistrates, my lords, they promulgate 144. It's not that we are not doing anything.
Then who is to do?
We are trying to resist, my lords. We are time to time we are taking steps, my lords, resisting, my lords.
Try and understand what we are asking you. Now, you have issued that instruction. Now, how do you execute it?
Police executes such, police, my lords, the district administration executes those, my lords.
What are you
In
saying?
the capacity of district
See,
magistrate.
This is additional district magistrate who has
Yes.
issued prohibitory orders.
Yes, my lords.
Is he so toothless? You want the police to step in the executive function?
My lords, I'll try to explain, my lords. My lords, it's a big.
You don't have to
My lords,
explain.
this is a festival time.
We understand
We
that.
don't justify, my lord. I'm not trying to justify those actions, my lord. But mob comes in, my lord. There's a law and order situation. Firing takes place, my lord.
So therefore, the additional district magistrate shall liaise with the superintendent of police.
My lord.
Superintendent of police would be under obligation to.
Yes. Everybody is
Execute.
cooperating, my lord.
Therefore, you can't say, one branch of the government can't say that the other branch is not following us.
No. Everybody is cooperating. Everybody is trying to contain the situation. I'm not saying that they're not cooperating, my lord. Issue is like mob is involved. Mob comes in, my lord. A large mob comes in.
Controls the mob. You don't expect this bench
We
to go
also do,
there.
my lord. They are firing incidents. Lordship knows, well, it's festival time. Lordship will respond, my lord.
This is
We'll respond.
surrender.
We'll respond.
Mr. Gogoi, what you're saying is surrender of the state authorities. Please don't say that. Please don't say.
No surrender, my lord.
You
but
are-
the situation is a bit different, my lord. On ground, it's a bit different.
Just a minute. When you carry out, when you carry out some demolition because of encroachment, mobs come. Don't you equip yourself to deal with such things? The judges will not go and handle the mob. Are you expecting us to handle
No,
the mob? So who will do it?
We are doing it, my lord. We are
So
continuing
therefore,
it. Trying, my lord.
we are not commenting upon you.
Yes.
We are only telling you that you have it in your cognizance. You have it, and therefore you keep on passing orders. These are in temporary orders. It has a life of 60 days under the Code of Criminal Procedure. So for those 60 days, you need to have it executed.
Right.
And where is the provision that if it is not executed, what action can be taken? You see, there is a judicial power,
My lord.
judicial power with you.
My lord.
So therefore, take that stand while answering posers in PIL. You have to take that stand. We don't say that you are not cognizant of all this.
My lord.
We do not even say that you are negligent of all this. But you are not exercising sufficient control to stop that. That again calls for judicial interference. No. Therefore, you have to do it. Take them.
My lord.
You file your response also. We have heard Mr. Fuken, learned advocate for the petitioner, and Mr. Gogoi, learned advocate for the Forest Department. The state is represented by MS R.B. Bora. Next. This writ petition has been filed seeking urgent judicial intervention to curb large-scale fishing in the water bodies of Kaziranga National Park and Tiger Reserve in Assam. The Land Council for the petitioner has informed this court
Publicity.
that people in multitude entered the park annually during Magh Bihu festival, which is celebrated between January 13 to 14, to carry out their traditional practices, which includes fishing in the water bodies in Kaziranga National Park. He has submitted that this is in flagrant violation of the wildlife protection laws and has a cascading effect which disrupts the already fragile ecosystem of the park. Such action threatens the biodiversity, including the endangered species, namely one-horned rhinoceros, many kinds of migratory birds, and approximately 42 varieties, 42 species of fish. The park, the Kaziranga National Park has been declared a UNESCO World Heritage Site and an important bird area. With these activities going unchecked, the status of the park is compromised. Mr. Gogoi, on the other hand, has submitted that the respondents are cognizant of this and therefore prohibitory orders have been issued regularly to control such illegal fishing in the water bodies in Kaziranga National Park. However, there appears to be some difficulty in executing such prohibitory orders for the reason of large number of people congregating at that site with religious fervor. Religious fervor. In any view of the matter, the protection of such site is necessary, or else there would be a violation of Wildlife Protection Act 1972, Forest Conservation Act 1980, and breach of various constitutional obligations under Article 48A and international obligations as well. We therefore deem it necessary to direct that the necessary prohibitory orders must be enforced. In the meanwhile, Mr. Gogoi to put on record the steps taken by the respondents in controlling such activities in the national park and the ways in which such activities could be effectively controlled. The matter requires immediate attention of the respondents. An affidavit be filed by the next date as to the steps taken for preventing such activities in the first and second week of January in the Kaziranga National.
Would my lord like to give a date, Milord?
Yes.
Could it be 5th of January, Milord, in the first week?
Before 14th, first week of January.
5th of January, if possible, Milord.
5th of January?
Let it be in 7th.
7th of January.
Very
But
Published.
pull up your socks, be ready for it.
Yes.
Deeply obliged.
May it please, my lords. My lords, I duly apologize, my lord. I was supposed to appear in item number 2, my lord, on behalf of Mr. M. Sharma, my lord. I duly apologize, my lord. I missed it.
What happened?
My lord, I was supposed to appear.
You have to mention this after we are through with,
I apologize, my lord.
after we are through with the list.
I apologize, my lord.
We will rectify our orders,
Yes.
but then not this way.
Yes.
You are disturbing the bench. All right. Yes.
Item 13,
Yes.
Lordship, the appellant assailed the inquiry officer order affirmed by the disciplinary authority and the appellate authority on 2 grounds.
Yes.
Lordship, the first ground was,
No. Tell us some background facts, no?
Lordship,
What has happened? The timelines.
the timelines, Your Lordship, okay.
What has happened? We must know, no?
Yes, Your Lordship. Lordship, there were articles of charge. I am the deputy manager of the bank,
Okay.
basically the field officer.
Hmm.
There were 2 other officers who were senior to me, who are not parties in this litigation, but whose conduct is relevant to the litigation. That is the assistant branch manager and the chief manager. Pertaining to me, articles of charge was framed on 11/2/19 at page 67 on the ground that I violated a rule 50, basically 54. Would Lordship want to see this?
General pencil.
Page 67.
The colored pencils.
Page 67.
Yes.
The rules of Rani Sana. Lordship has page 67.
Yes.
This is the article of charge framed against the appellant. It says during your tenure as the field officer at Dadra branch from October 17 to August 2018, certain serious irregularities were alleged to have been committed by you. And due to such irregular activities, the bank is exposed to suffer a pecuniary loss to the tune of rupees 205.31 lakhs besides reputational loss. You have failed to discharge your duties in this regard in the desired manner with due diligence and utmost sincerity as per bank's extant norms and instructions. These acts are unbecoming of an officer. In this manner, you violated Rule 54 of the SBI Officer Service Rules that is applicable to you. Imputation of charge on the basis of which the allegation charges are based are furnished in the Annexure 2, and the list of documents on which the bank relies is Annexure 3. And I'll come back to the imputation of charges later.
Yeah.
This is the first thing. Then, Your Lordship, I retire, which is on 28/2/2019. And as per their rules, which is dealt with 19(3), even if I retire, the disciplinary proceedings continue. Thereafter, Your Lordship, on 18/9/2019, the disciplinary authority forwards the inquiry report, the inquiry report is dated 3/9/2019.
Yes.
Which is at page 506. I'll come back to it, Your Lordship. Thereafter, this inquiry report, we file our representations, etc. And thereafter, 9/12/19 is when the disciplinary authority affirms the inquiry officer and passes its order. And that, Your Lordship, is page 319. And we are foisted with the major punishment and the most grave of them, which is dismissal of service. Thereafter, we file an appeal, and the appeal is also dismissed on 1/6/20. And thereafter, we come to the single judge. Now, Lordship, the single judge we assailed on 2 grounds. The first is perversity, that the findings of the inquiry officer were not found on evidence. That's number 1. Number 2 was parity, that there's a violation of equality doctrine. Why? Because the 2 other officials, the assistant branch manager and the chief manager, were also held, charges against them also were leveled. Certain charges were proved, and it is our contention that we are on the same footing, and therefore the punishment should have been the same. I got the gravest, which is dismissal of service. They just got the first of the.
Appears for the other side.
This is, there is no standing council of SBI.
No standing counsel. So notice has to go.
Yes, your
Why were we hearing?
Yes, your lordship. I thought you were dismissing my matter. That's why hearing.
We have heard MS Goswami, learned advocate for the appellant, who has questioned the judgment of the learned single judge, whereby he has refused to interfere with the order of dismissal. The major contention is that the learned single judge, major contention on behalf of the appellant is that the learned single judge did not at all consider that the decision of the did not at all consider that the decision of the inquiry or disciplinary authority was not based on the findings, and that similarly situated persons were treated differently so far as quantum of punishment is concerned. Let notice be issued to respond numbers, let notice be issued to response number 1 to 6 on steps being taken by the appellant within a period of 2 weeks, both modes returnable on March.
Obliged.
2nd of March, 2, 3.
Obliged, your lordship.
Item 14.
May it please your lordship.
Yes.
My lord, at the outset, may I admit one thing, though this matter pertains to Surfacy Act, but the notice issued by the respondent bank under section 13(4) is not under challenge here. What happened?
And even if you're challenged,
Well-
you'd have relegated you to DRT,
Yes,
no?
true. But my lord, the issue involved here is something, perhaps in my humble contention, subject to your lordship's guidance.
You don't have to be so tentative in your
My lord,
arguments.
On
This is
examination.
because you're tentative because you know the law.
No, my lord, my
You
lord,
know the law, therefore you're not very affirmative in your submissions.
I know I'm on slippery grounds, my lord. But
Now, we Beckett,
my lord, one thing that I have examined insofar as the provisions of section 13(4) is concerned, I mean, the provision of appeal under section 17 is concerned. Subsection 2, 3, and 4 are only concerned with whether the action taken by the bank under section 13(4) was in accordance with the acts and.
so there are about 22.
I'm carrying
Okay.
3 of them at least. Mardia Chemicals,
No,
Sattvarthi,
there are
Kattand, and
22 checklists, which the district magistrate or DC or the
absolutely. Now,
CMM has to see.
my lord, what happened post the issuance of 13(4)?
Mardia Chemicals, you have
Mardia
just said.
Chemicals, Sattvarthi, Tandon, everything is
So
against. me.
therefore, instead of you being tentative, we are on the back foot. We don't want to interfere here.
My lord, just 2 documents, if I may be permitted to show, my lord.
That we are not gagging you, we are not stopping you,
Well,
but you know the law.
I know,
We
ma'am.
would always relegate you to the DRT
True.
unless everything is perverse.
My lord, but here, one thing that I may just be allowed to humbly contend, my lord. I don't find any anomaly insofar as the notice under 13(4) is concerned. Only thing is, only after that what
And
happened.
that is another impediment in our passing any
My lord,
order.
I understand, but only thing, my lord, that happened thereafter was I approached the bank asking for allowing me to pay the overdue amount because of which the account was declared empty.
That's right. You needed to know that.
Yes, and they in fact informed me there's a letter, there is a document at page 29, Annex 6, which says that the overdue amount is this.
Mr. Counsel, would you like us to deal with this, or would you, after some arguments, withdraw this to approach the DRT?
My lord, DRT, of course, under 13, against 13(4), DRT will be the only alternative.
Satyavati Tandon holds the field even
Absolutely.
today,
Absolutely.
and the latest judgments also say that
Absolutely, ma'am.
we are not going to hijack all
Ma'am.
such things
My
there.
lord, my lord. The
I think
only,
you go there. These are issues which can be sorted out.
my lord, I leave it up to your lordship, sir.
No, we leave it up to you. Either we dismiss the petition or we relegate you to there.
I'll take the relegation, my lord.
Here's Mr. You are Mr.
D. Chakravarti.
Mr. D. Chakravarti, learned counsel petitioner, after some arguments, seeks permission to withdraw this application in order to agitate his claims before the DRT. Gotti.
My
This petition is thus dismissed as withdrawn with the liberty of foresight.
deeply regret.
Item 15.
dumping ground there. Coming for the first time,
No, Lordship.
did we pass any order?
Yes, Lordship, department filed the reply and we also responded to.
Filed a counter affidavit.
Counter affidavit also
When?
filed.
On the 5th of September, my lord.
You filed your counter.
Yes.
Where is that? Have you received a copy?
Yes, Lordship.
Would you like to file a reply to that?
Already
You
filed.
have filed the reply.
Yes.
What counter affidavit is it there?
Pages 64 and 65 of your lordship's brief,
Let's see.
paragraph 4, my lord.
64 and 65.
Yes, paragraph 4. No alternative land, my lord, other than that dumping ground. And that is government land. Yes, my lord, the district commissioner highlighted it.
Which paragraph are you referring to?
Paragraph 4 of your lordship's.
Read that.
With regard to paragraphs 3 and 4, the opponent states the statements are not true. There is no feasible alternative land for dumping other than Uchila dumping ground, comprising an area of land measuring 10.5 bighas, which is fully protected by boundary wall, and the dumping of waste is being carried out by maintaining adequate hygiene. And for scientific disposal of waste, work orders have been issued by the Hailakandi Municipal Board.
What is your reply to this?
Lordship, we have filed a reply, Lordship, page, in our reply, Lordship, page 63, we have annexed a Google map, Lordship.
That's right, but the area where the dumping of garbage is being done,
Yes.
that's a government land and fully protected.
No,
What
no,
can be
Lordship.
done? Where would the garbage go?
No,
We will tell them to sort of process that,
Lordship,
use it as a landfill.
Lordship, it is not protected. They are lying this, Lordship. We have annexed this photograph, Lordship, and also annexed in the petition also, sorry, PIR also, Lordship, page 18, Lordship.
No, 63 is the photo has been taken from above, as if it's an aerial photograph. How do we know?
Lordship, the distance
If you want,
we have mentioned,
distance
Lordship.
is all right. Distance could be 500 meters, distance could be 1 kilometer, distance
Lordship,
could be even less.
These are the distance of only
But what
40
is
to
to be
50
done?
meters.
Can you find an additional site, MS Sharma? There are many schools, residential areas.
We have stated in our affidavit also. Lordship grants me a few days.
But this photograph we can't appreciate. If you want us to interfere, please provide us with, we would be interested in interfering.
Lordship.
Now you can't have, we understand that. I have lived for some time in a place where very near was a dumping ground.
Yes,
There was a stench all over 24 hours. Difficult to stay. We will consider it,
Yes.
provided you dispute the facts stated in the counter affidavit.
Lordship, there was no boundary, Lordship, only the two sides they have covered.
Mr. Counsel, if you
Lordship, we will,
contradict an oath, we would require it to be contradicted by an oath.
Lordship.
Then we will have our own commissioners sent and we will inquire. But otherwise, no, this appears to have been taken from some distance. It's a Google photograph.
Yes, yes. Okay, Lordship, we will provide another.
The local residents of, what is your name?
T.H. Chaudhary. T.H. Chaudhary.
Heard Mr. P.H. Chaudhary, learned advocate for the petitioner, and MS Sharma. MS Sharma for the state. The local residents of Kuchila Paikan area in Hailakandi district of Assam have sought intervention of this court for stopping the open dumping of garbage and solid waste at Moilatila. The petitioners claimed that such dumping does not have the sanction of law, as the activity is unregulated, the claim of the petitioners is that what was started as a remote area for what was started as landfilling for a remote area has now become a nightmare for people living in the neighborhood. 300 families, according to the petitioner, reside near the dumping ground. There is a veterinary hospital, school, temple, mosque, and a PWD road, which is busy for the entire day. Because of the unregulated dumping at such a site, it is leading to a kind of health catastrophe. The residents witness truckloads of mixed waste being dumped at the site without any protective barriers, liners, or daily soil covering. This has led to groundwater and surface water contamination, air pollution because of the release of methane, bracket CH4 gases, soil degradation, etc. The petitioners have also alleged that the action of the municipal corporation in dumping the waste at that site is a blatant violation of scientific waste management principles and solid waste management rules of 2016. A reference has also been made to a memorandum dated 25th of April 2019, issued by the Assam Urban Development Department Office, Assam Urban Development Department, which mandates phasing out of open dumping, bio-mining of old sites, and capping legacy dumps to prevent environmental harm. In response to the aforenoted allegations, the state, through an affidavit, has submitted that there was no feasible alternative for creation of a dumping site other than Kuchila dumping ground, which is spread over an area of about 10.5 bighas, and that area is fully protected by boundary wall. The dumping of waste is being carried out maintaining adequate hygiene for the scientific disposal of waste. Work order has also been issued by the Executive Officer, Hailakandi Municipal Board, for establishment and commission of material recovery facility and waste to compost plants Work has also progressed towards development of sanitary landfill site. This court has also been informed that the work order for legacy waste treatment of Kuchila dumping ground has also been issued by the Director Municipal Administration, Assam, on 13/9/2024. The further contention of the state is that the schools are located at a distance from the dumping ground, and such dumping site at Kuchila is not disturbing, ought not to be of any disturbance to the residents of the locality, for the site spreads over a big area which is effectively boundary walled. The Land Council for the petitioner submits that such claim of the state is absolutely incorrect, actually, and the dumping ground, Kuchila dumping ground, is completely exposed without any boundary wall. In support of the aforementioned contention, a Google photo has been produced before us, which does not depict anything. The Land Council for the petitioner submits that by the next date he shall produce before the court the recent photographs taken of the land site. Let that be done by the next date before we pass necessary orders or close the petition, re-notify January. No, you have to give it by affidavit. We'll not accept any photo like that.
Sure, Lord.
And you have to state who has taken the photograph, where, when, in presence of somebody.
Okay.
All right.
30th January 30. Timing item 11.
Meet Pizzola.
Yes.
Well, I'm sorry I was not there.
Yes.
The question.
This is not the only court.
I'm a black
Yes.
gossips.
Who appears for the other side? Is it coming for the first time?
No, my lord. In fact, there was a delay that was condoned after hearing the other side, my lord.
Like it appears. What is his name? Kumar was there.
Yes, yes.
He is Mr. R. Dubey. Mr. Dubey, learned advocate for the appellant, is present. There is no appearance on behalf of respondent. Sole respondent.
Let is the sole respondent.
On behalf of the sole respondent. This is perhaps because of the fact that his name is not reflected in the cause list. We take it up tomorrow, inform him.
My lord, I'll do.
The Mr. Dubey, learned counsel for the appellant, undertakes to inform the counsel for the respondent so that this matter could be disposed of expeditiously. Let this case come up for consideration tomorrow. The registry, in the cause list of tomorrow, the name of counsel for the respondent must be.
Well,
inform him today.
I'll do.
We don't want to keep these cases
Yes,
pending.
yes. No, very
For
short,
reason
short,
there is-
short issue, my lord.
All right.
Well,
Item 16.
My lord, may I please, lordship? Lordship, in this matter, I want some further time, my lord, to file our.
Who are you? Who you
I'm
want?
department, I'm representing department, my lord.
ENRD cable?
Panchayat and Rural Development Department.
What do you have to say? What is your stand?
My lord, our stand, actually, my lord, we have already annexed affidavit
You have
before the,
succeeded, but then we might.
on legal points, I was,
Mr. क्या नाम है इनका?
as Datta.
Doctor.
Datta.
You're a PhD doctor.
No, my lord, S Datta.
Datta. Mr. S. Datta, learned standing counsel for PNRD, seeks some more time to respond to the petition.
My lord.
Let this
I
come
love
up for consideration sometimes in February.
My lord.
9 February.
Highly obliged.
Item 17.
Chaudhary was up there in the last.
Lordship, instruction was directed to be taken, my lord. Receive instruction. I just need 1 day time, my lord. And apart from that, your lordship.
Who appears for the petitioner?
Lordship,
For the appellant.
Lordship, Mr. Counsel is on lake, Lordship, after some time, Lordship.
Yeah, a prayer for Passover has been made on.
Yeah, in this case, I filed a debate.
You have filed a?
Yes, I filed debate on my law.
Your respond number 8.
Yes, 13/11/2024. I filed a debate. But they have filed a bill immediately thereafter and make it debate. The bill has been debated because some court has not paid to them. After 9 months, they have listed this matter. It
All
came as a
right.
debate.
So the purpose of filing a caveat has been discharged, no?
Yes, sir.
Only
You have the
these 3
notice?
months.
No order, and otherwise also be rest assured, we would not pass any order in the absence of the party who can be adversely affected. All right? Let us
Lordship,
take
at the
it.
face of it, the tender notice cannot
Either
stand.
you argue this case. or you
Lordship,
take
because
time.
learned single judge on a different point has set aside the tender notice. Because under mines and mineral concession rules, it has to be done by e-auction, my lord. That has not been adopted in the present case. Neither party would be eligible for that.
After that case,
Now, are you arguing for this?
No, the instruction sought for is very limited, so I'll be placing it any day. coming to Lordship.
Then you say that we will not wait for the council, we will allow the petition.
No, my lord, I have option on my law. Different step has been taken. Earlier step has been taken, that point is not there.
Ms. Bhuya,
Ah,
this cannot be your stand now.
Federal has been.
This cannot be
They
your
have not
stand now.
taken the plea, my lord. Lordship
Let
just.
them not take the plea.
My
This
lord.
can't be your stand. There is some miscommunication with you.
Already
No,
there.
Lordship, may kindly have a look.
Just a minute, then
My
you withdraw the tender.
Yes, my lord, it may be set aside, although it would go against our Lordship department. Lordship may set aside the tender.
No problem. Just.
They have the statement.
এখন বিয়োগ না করো।
That point has not been raised before a rational single judge.
This is his document. Now you should.
Lordship, may kindly have a look.
About of?
The order, my lord, the Parvachara on the ground of non-initiating tender in terms of section 34 of Assam Minor Concession of 2013, the tender notice has been set aside by the learned single bench. Oh, it goes against our department, but Lordship, my duty is to point out before this honorable.
It concerns the same.
Yes, neither would be, no one would be.
This become infructuous. Mister, you'll have to challenge this if you, in this caveat, you can't do anything. This is not your case. Considering the stand of the state, that by virtue of a judgment of the learned single judge, the entire tender has been cancelled. I think.
Lordship,
this
may kindly have a look at it, my lord.
petition- We will take your stand. We will not look at the judgment. This is not under appeal.
Lordship.
We will take your stand that you have withdrawn the tender subject to, because of the order of the learned single judge,
Lordship.
which you have not challenged.
Yes.
So therefore, this petition becomes infructuous.
Lordship, may I take instruction to, in that regard, whether they've cancelled it, because learned single just set aside the tender notice. Whether the further steps have been taken by them or not, what further steps they have taken.
Let Mr. Chaudhary come. You wait for some time, pass over for few cases.
এখন আনবিব হ্যাঁ মাইনর কনস্ট্রাকশন রেগুলেশন
Item 18 and 19.
Affidavit has come. Will you pass somebody? Yes, who appears?
The last occasion, Lordship directed to file an affidavit.
Yes.
So that I have already called for, Lordship. I have stated at paragraph 4 and 5, Lordship.
You filed affidavit when? Oh, sorry, it has
Yes,
come.
we have called, I have called for it.
Paragraphs?
4 and 5. So 6 also.
Then why do we interfere? Why would you be permitted to select one particular retired employee?
No, Lordship, they have filed some cases and those cases either pending and in those cases they succeeded. So we have and one such case that is OA number 231/23 where Lordship may find the relevant portion where although the order has been here page 181, the validity of subs. But in this writ petition, that 9/12/2020 memorandum was also not challenged. But in those cases, it was challenged and the validity of that was not
Whatever it is, but he should not be
Denied.
targeted, no. Then leave it. Don't tell him.
There are 11 benches, Lordship, and 40 consultants are working, except the 2.
I think the decision is incorrect. Even this remuneration, even it is controlled by the agreement between the parties.
Lordship.
It has to be in consonance with the circular.
Yes.
Because it has some fiscal connotations.
Lordship. Lordship, otherwise,
Not that you have any strong ground, but because of the fact that they are not pursuing the matter.
yes, Lordship.
Otherwise, we would have set aside that judgment of the land single.
Lordship, that order has been challenged. The order of the CAT, that is page 181, that is, although Lordship may kindly come to page 181.
You tell us in how many cases you have succeeded in challenging it.
Lordship, this 181 may kindly come to page 181, Lordship. This here,
And other orders you have succumbed. Other orders passed by the.
some are pending, some are pending.
You have to give us those details, no? Then we keep it pending.
But Lordship, this order that has been challenged in Delhi High Court and this is this is admitted and it is now fixed on 17 to 2026.
Understanding what the court wants you to do. Those details are irrelevant now. You tell us what is if there is any litigation pending, we will await that decision because prima facie, we are only at one place that you are following it selectively. You're cherry picking people.
Cases filed, Lordship, but subsequently they have not. In CAT, it was challenged. But in those cases, Lordship, 9/12/20 order was challenged, but in this writ petition, it was not challenged.
Pursuant to the order dated 12/11/2025, an affidavit has been filed on behalf of the appellant / Union of India, stated that the memorandum in question, namely, which is that memorandum? Memorandum in question, namely the office memorandum dated 9/12/2020, issued by the Department of Finance.
Ministry of Finance, Ministry of Defense.
Issued by the Ministry of Defense, is not being implemented and applied across the board in cases of post-retirement contractual employment in armed forces tribunals. However, it has been submitted on behalf of the appellant that most of the orders of the tribunals are under challenge. A request therefore has been made with the decision in one of such cases which is slated to be listed on.
Oh, Lordship, this I have, that I have already annexed, Lordship. Delhi High Court is fixed on 17/2.
Slated to be fixed before Delhi High Court on 17/2/2026. 26. Let this appeal. In the meantime, you don't deduct.
No, he has already,
Lordship,
we have not deducted, whatever already, he is not continuing
This
now.
matter.
Lordship, my case is different, Lordship. The judgment,
We are in, if it is different, then we set aside this judgment.
yes.
You're interested?
Which one, Lordship?
What is Tamildar, you don't know, you don't assess which side the wind is blowing.
Sorry, Lordship.
ये क्या लिखा है?
Yes.
Let this matter come up for consideration sometimes in February 2000.
Obliged, Lordship.
23rd February. Item 20.
The last occasion, Lordship was pleased to issue notice to Lordship, but affidavit is not yet filed by the Finance Department. Your Lord.
Affidavit has been filed.
Not yet filed, Lordship, by the
Mr.
Finance
Das?
Department.
Finance is to respond.
Respond, Lordship.
Who appears for finance department?
Mr. B. Gogoi accepted notice, Your Lord.
Where is Mr. Gogoi?
Additional Gogoi. Dear
Inform Mr. Gogoi.
Lord.
We are keeping it for some time. Anybody who can represent the finance department.
I'll inform you.
You're appearing for whom?
I'm for the High Court.
Okay.
Much.
Item 21.
Same.
Both are same.
Item 22 to 24.
Yes.
Lordship. Here, Lordship, the matter relates to Surrogacy Act, Lordship. The petitioners intended to go for a procedure of Surrogacy Act. And initially they tried and they failed, Lordship. Subsequently, Lordship, when they were undergoing that process, that act has come enacted, Lordship. And because of that barrier, they have to come before this honorable court by filing a writ petition. That your Lordship will find page 41. There was some observation that the act is not fully implemented in the state of Assam. So therefore, there is no bar for going for that procedure.
Under section 35 of the act.
Lordship. And thereafter, Lordship, they initiated proceeding in the state of West Bengal, Lordship. But the central government again passed a notification, Lordship, that the donors cannot be used by the intending couples. So therefore, this present writ petition has been filed. But in the meantime, Lordship, they have withdrawn that notification so that now they can use the donor's egg. The only barrier is that age, Lordship. Now, the same issue was pending.
No, tell me one thing, whether the process was initiated and it continues.
Yes, Lordship.
No.
It was,
is
that
process initiated, but it failed, no?
It failed. It failed.
It failed.
It failed.
So now it will be a fresh process.
Fresh process.
Fresh process post the amendment.
Lordship.
Post the amendment.
Lordship.
Therefore, those certifications will be necessary, no? The two cases that you have referred to,
Lordship.
one from Kerala and one from Delhi.
Lordship.
Those two cases, or one from Delhi, but decided by Supreme Court, interim order under 142.
Lordship.
Despite that,
Lordship.
the principle was that if it has started before the amendment,
Lordship.
then it can't be halted midway because it will, adversely affect the health of the mother,
Lordship.
health of the donor mother.
Lordship.
Right.
Lordship.
So that is not your case. Unfortunately, you tried IVF, that failed.
Lordship.
You were suggested surrogacy,
Lordship.
you started.
Lordship.
You started, but that also failed.
Lordship.
Now it will be a fresh start.
Lordship.
So far as your objection with respect to no appropriate authority having been constituted, that's gone. Now the authority has been constituted. But the fresh certification with respect to age, health, and other things will have to continue. We can't, because this is no fundamental right. You have a right to bear a child, to right to health, but then there is no fundamental fundamental right for surrogacy. So we will not question the correctness of the decision here. for the checks.
Lord,
You know how surrogacy thing is being misused.
Lordship, that,
So therefore, we will not go for any change or scaling down of the conditions.
Lordship,
Suppose you had started and this process had continued,
Lordship.
then we would have given you the same liberty.
Lord.
Right?
Lord. The only thing is that, Lordship, because of that age bar, that is the difficulty.
That you have to follow, no? No, there is no sign. Where's the question mark?
Subject to correction, so what, Lordship?
Let's see. Let's see, I've got those case laws here.
Lordship. Vijaya Kumari and another.
I don't think we can help you. We can't help you. You have to obtain that certification. That's very sorry to say, but what to do?
That certification they will, Lordship, apply for, but that only because of that age bar, that is the difficulty.
That's all right. So age
yeah.
certification also is necessary, no?
No, here, Lordship, subject to correction, what I have understood, Lordship, that if they have, Lordship, earlier started that process, then.
Earlier started that process and the process continued. Look at the judgment.
Yes, that I have.
We're looking
seen.
at the judgment. The process continued.
Okay.
So midway, if suppose that the pregnancy is carried for 9 months,
Yes,
suppose by 5th month or 4th month or even 1st month,
Lordship.
if it is carried, then this notification will not be applicable to that person, but
Applicable.
yours has failed, unfortunately.
Lord. But if your Lordship see page, just I'm referring to.
Both the cases where the relief was granted was with respect to that, without impinging on the correctness of the decision of the act and the regulation.
Lordship. The only thing is that
Have you crossed that age?
Lordship.
Have you crossed that age? Has the
Yes,
woman
yes,
crossed
yes,
that age?
yes, that they have.
They will not. It will not be medically advisable.
But because of Lordship pendency of these cases, Lordship, they have,
It's a serious matter, no?
Lordship.
It deals with the sentiments of people,
But
the
if-
expectations,
yes.
life,
Lord.
marital relationship, everything goes haywire.
But
If
it is
people are focused on the progeny,
Lordship. But if it is for commercial, then it is difficult. But here,
yeah, that is why we are thinking.
Lordship.
We understand that this process started sometimes in 2010,
Lord, 16.
16.
16.
How many? 10 years have gone by.
Lordship. And in fact, Lordship, page 28, there, page 27, Lordship. But 29 also, there already the.
Of course, we are nobody to advise you,
Lord.
but you can advise your client not to go for this. Now, there's a huge risk of the child coming out of the womb with some malady. This has not come out of the blue. All these restrictions and regulations have come out of thinking, scientific, research, data, statistics, etc. And therefore, contemporaneous with this was the adoption laws. The changes made.
No. Lordship can direct them to go for some medical that they are physical concern.
That is there. That is within the statute. Why
If they are physically, Lordship.
you do one thing. You apply. Don't press this. Otherwise, we'll dismiss this petition. We'll dismiss this petition. So one objection is over. Section 35, no constitution. That's over. That notification also came. That was withdrawn. But this process failed so far as you are concerned. In that case, we will say, if we have to decide this petition, we will say that this certification would be necessary with respect to age, health, anything. And this is a fresh start. Therefore, it is post the amendment.
Lordship.
In that case, you don't even get the platform to say that, well, maybe what is that called? The number is there. Age is only a number. I am absolutely fine. I can.
In that case, Lordship may give me some time, I will.
Discuss to tell us because we will deal with law only.
In that case, Lordship may give me some time, I will obtain a.
Take a call tomorrow.
Lord, next week, Lordship.
Next week, it will be difficult. We wanted to help you.
Lordship. Next week or Friday, Lordship. Friday.
Friday.
Lordship. Lordship.
If they're not ready to give you the consent, then we decide it.
Lordship.
We'll be least abrasive
Lordship.
so that we leave it open for the medical authorities to decide.
Lordship,
Lovely.
item 24 relates to IBA. That will not be tagged with these matters, Lordship.
Now we'll hear it on Friday.
Lordship.
We'll hear it on Friday.
Item 25. I am for the respondent bank, Lordship.
Yes.
This matter has practically become infructuous.
Not practically. It is infructuous.
Hearing has completed, madam, before the deity and is posted on 27/1
For judgment.
for judgment. My only prayer is that, my lord, the benefit of interim direction may be continued till 27.
Don't ask for us. Don't ask now.
Otherwise, my lord,
This petition has become infructuous. Take it. What is it? Sir, your name, please.
N. Nath.
Mr. N. Nath, learned advocate for the petitioner, is fairly submitted that this petition has become infructuous.
I am for the respondent bank.
Mr. So-and-so appears for the respondent bank. The petition is just as having become infructuous.
Obliged.
It was for all practical purposes infructuous at the time of filing of the petition.
We made out some
On
case,
principle
man.
of law.
We made out some case
All right.
against the court, my lord.
Yes.
26 and 27.
The matter is pending before the Supreme Court, no?
May I please, your lordship, this matter is still pending before the apex court, my lord.
Yeah. Let this matter come up for consideration. On so and so date in March, awaiting the judgment of the Supreme Court in so and so.
16 March.
Obliged.
Timing matter. Item 17.
Mr. Chaudhary, this time to feel happy without arguments.
Yes,
Looks like. So let them, you want, if you don't.
Naturally, my lord, partly it has my prayer has been allowed to the extent, my lord.
Entire. Now you apply afresh.
Yes.
If he has to, you don't.
Yes.
Just a minute, because the caveator is here.
Yes.
Now he questions that decision. You don't question.
I
this
don't,
decision. You withdraw this petition. You can't press Mr. Chaudhary to argue his case if he doesn't want to. You file your petition.
In view of this order, I am not pressing.
In view of the, what is it?
Settlement is already given to you.
That may be set aside, my lord. I'm making the submission.
Just a minute, Mr. Counsel, try and understand. Settlement has been given to you. You have been impleaded here as respondent number 8. Your occasion comes only when he presses the petition. Now, we are not talking about what has happened. Now, for some reason or the other, you will have to challenge this. You will have to challenge this.
So I am the respondent.
Ore, bada mushkil hai. Then you have lost it, no? Then you go before the division bench.
No, debate Beleg is another person.
Originally, repetition, I am my lord.
Yeah.
My challenge in the.
What locus do you have today?
I already said I follow.
आपको मैं समझा नहीं पा रहा हूँ. I think I
Lordship,
just a minute. Ms. Bhuiyan, you have done your job. Now, because he has taken the care of filing a caveat petition, he has got the settlement in his favor. Let the rug not be pulled from below his feet. Therefore, we are making him understand
This order is not in our case, my lord.
Very good.
It is separate.
All right, so be happy. He is not contesting it. What is there? Be
It's not
happy.
our case, my lord. Our decision different.
All right. So therefore, be happy.
My lord,
He doesn't want to press this.
I am no.
In view of the judgment of the learned single judge in WPC number 6716 of 2021, Mr. Ken Chaudhary, learned senior advocate, does not press this appeal. Stop. The appeal is dismissed as not pressed. Clearance slips there.
Timing item 20.
In these two matters, these are all employees of the Honorable Court, Millard.
Yes.
I think the finance will have to file their affidavit, Millard.
Mr. Gogoi,
But
I appear for the judicial as well as the finance department. I'll file my affidavit.
you have to file, no?
Yes.
Now, we don't want to give an impression that we are for the petitioners because they are serving us.
Lordship.
But then we can't force you.
My lord.
Pay parity is something which decision has to be taken by you.
Lordship.
But why should you not take that decision is the question which we can consider.
Lordship.
Correct?
My lord, give the reason.
Mr. Gogoi, Mr. Gogoi, learned advocate for the finance department submits that necessary response affidavit shall be filed by the next day,
But
February.
publishment.
16 February. Supplementary list item 38 for admission.
Next year. Item?
Supplementary list.
37 हो गया 37 बचा हुआ Adjournment. अच्छा,
Where is the lawsuit?
Yes,
Well, this matter relates to suspension, my lord.
louder, sir, louder. Louder.
My lord, the name of the respondent, my lord, has been shown as Ziasa, which should have been, my lord, SC Health. My friend is there, my lord.
Gogoi, get ready in the matter.
My lord, one copy may be served.
Let a
to us.
copy be served.
I've served the copy, I've served the copy to the health.
Give a copy to him now.
I'll give him, my lord.
Then my lord,
Tomorrow?
yes, tomorrow or yes,
Tomorrow, day after,
suspension.
this, it's a suspension order
Lordship.
which was challenged.
Yes. Only
Now,
thing, my lord, the review.
do-
whether it was-
Review done. The departmental proceeding started,
Yes,
charges framed.
Lordship.
So in that case, Ajay Chaudhary has been complied with.
My lord, it has been.
So
complied.
therefore, the London single judge.
Only thing, my lord, he may cooperate because he was subsequently, my lord, he was arrested again. Now he is.
That's irrelevant for us. That's irrelevant for us. He is challenging the judgment. We are, nothing more can be done.
My lord.
We would only reaffirm what the single judge has said.
Then tomorrow, my lord.
Or we can only say that the departmental proceeding be expedited and be concluded expeditiously.
Lordship.
If we want that, we will pass an order. He will not,
my lord,
he
that's-
will not be required to spend money on
Yes.
making photostat copy of your petition. He will also not be.
Let's take up the matter tomorrow, my lord.
Huh? Then in that case, you spend from your pocket. Give a copy to him.
My lord, I'll give him, my lord. But I also prepared one list of date, let's keep on that.
Day after tomorrow.
Day after tomorrow.
My lord.
As prayed for on behalf of the his appellant, as prayed for on behalf of the appellant, let this matter come up for consideration on 10/12. Mr. Gogoi, just have a look.
Lordship.
Oblige, my lord.
Azaleo, on that date, the name of Mr. B. Gogoi, learned advocate for the finance department, and learned advocate for the
Health department.
health department shall be reflected in the cause list.
Oblige.
Item 39.
Item number? Yes, sir.
39.
Yes.
Lordship, before my colleagues start, Lordship, I'm appearing on behalf of Netfee. Lordship, we haven't been served with a copy. Netfee have a standing counsel, Lordship.
Serve him a copy. Give him a copy. We are hearing tomorrow. It's an interlocutory matter.
Yes, Lordship, Lordship.
The law is very well settled.
Yes, Lordship.
For against the order refusing to condone the delay of 15, 16 days or 20 days or 100 days. If the DRAT would compel him to file, to deposit that amount, that's bad.
50%, Lordship.
50% or reduced to 25%, it's bad, no amount. Because there is no determination of debt.
In fact, Lordship, the original Lordship judgment, it was not an ex parte judgment. It was a judgment pass on contest. He entered appearance, file is written.
No, whatever,
Yeah,
fine.
Lordship will take.
That's all right. So we are.
He knows everything. He knows everything.
No, mister.
Yes, sir.
He has a right to argue.
Yes, sir.
If we are observing in your
Yes.
favor, you need not silence him.
No, yes.
We will be hearing it. Now look at this. Now, right from 2015, Seth Banarsi Das Gupta, that is the lead case.
Lordship.
They decided that DRAT shall not ensure for that prerequisite of payment of 50% of the amount in question. But that shall be triggered only if there is a determination of debt.
Lordship.
Suppose there is an interlocutory order. Suppose the DRT refuses to entertain an additional affidavit
Lordship.
and the party wishes to challenge it. There also you will have to deposit.
Lordship.
Not at all. So therefore, condonation of delay. I mean, though he has prayed for treating the petition before DRAT as miscellaneous petition, we will not do that. We will explain the act. We will explain the situation. We will explain the fact situation and tell the DRAT not to insist for that.
Lordship can have this matter tomorrow so that
Tomorrow.
I can go through it.
Therefore, you just go through Seth Banarsi Das Gupta. This is perhaps of 2015. Then Narayan Chandra Ghosh. There's so many cases. In fact, this court, your Chief Justice has decided this in a matter. No, just look at the law, not the facts.
Perhaps, Lordship, because it was not an ex parte judgment. That's
Even
why he
if it is an ex parte judgment.
That's why, Lordship.
So there is no judgment by DRT, no, on the issue. He would come back to DRT. What is your name?
N. Mahendra.
Mr. N?
Mahendra.
Mr. Mahendra will come back to DRT. Because DRT did not condone the delay.
Lordship.
Therefore, he has gone to DRT. He cannot come before us.
Lordship.
DRT says that deposit 2 crores.
Lordship.
Then I will see whether the refusal to condone the delay is correct or not. This is, I mean, even if it were not laid down, we would have said so.
Lordship.
Tomorrow, as jointly prayed for on behalf of the parties, re-notify on tomorrow.
Yes, sir.
The matter is urgent, no, because there would be taking over of the possession of his property.
No, Lordship. It's a order passed in the
Lordship, the order.
RDVBR,
Order to
not
be
the
stayed.
SARFAESI Act. Lordship, in fact, he was a judgment debtor. Execution proceeding has
Whatever be the case, it's a
the
settlement.
salary was directed to be attached. That's why, Lordship.
So therefore, he needs to argue this before DRT, no? Tomorrow, is there some difficulty? We can keep it next week.
Tomorrow, Lordship. Tomorrow, day after tomorrow, any day.
Tomorrow.
Day after 10, 12.
Day after tomorrow.
Lordship.
Lordship, the matter is fixed at on 11, 12 before the DRAT. So I want the matter to be taken up tomorrow.
Seeing the urgency, we take it up tomorrow. No
All right.
facts. We are not discussing on facts.
Lordship.
9, 12. Daily list, sorry.
Just look at this. The proposition of law is that the requirement of prerequisite deposit for entertaining appeal before DRAT gets triggered only if there is a determination of the debt amount by the DRT. Nothing beyond. My citation may not be correct, but the principle of law is correct. Just find out.
Daily list, item 29 for final disposal.
Wait, in the lodge.
Yes.
My lord, the matter relates to pay parity of Ayurvedic doctors. Now, my lord, as far as our entitlement is concerned, it has already been determined by the single judge. Only thing is, my lord, while implementing the order of the learned single judge, my lord, some discrepancies has come out. Whereby, my lord, please come to that order of this honorable court
Let us
at
see
page
the-
158, my lord.
Yeah, बरोबर है.
Please come to page 160. Paragraph 2.
Just a minute. Mr. Chaudhary.
Yes.
My brother has pointed out an earlier order passed by this bench.
Yes,
Uh,
that's their order I was trying to. Honorable Justice Michael Zathan Kumar.
no.
59/2020.
59/2023. We will read out that order. Maybe you will not be having that order. Mr. Kane Chaudhary, the order reads, Mr. Kane Chaudhary, learned senior counsel representing the appellants urges that the writ petition was dismissed based on the judgment rendered by Honorable the Supreme Court in the case of State of Gujarat and others versus Dr. P.A. Bhatt and others reported in so-and-so. A review application has been filed against the judgment of Dr. P.A. Bhatt.
Yes.
And thus it would be apposite to consider the instant appeal on merits only after the fate of the review petition filed before the Honorable.
Review was dismissed.
Review dismissed. Then everything by.
No, my lord, it's slightly different, my lord.
So now you want to argue?
Yes, now, my lord, there are two sets of judgment. One regarding age of retirement, one is pay parity. On pay parity, my lord, there are three Supreme Court judgments which are all in favor of the Ayurvedic doctor. And relying on all these things, my lord, in my earlier round of litigation before the learned single judge, my prayer was allowed. But while implementing that order, an administrative order has been passed, which you have challenged, which was again dismissed. That's why I'm before your lordships again.
Let's see.
Yes.
Let's see the impugned judgment here.
No, before that, if your lordships would kindly come to page 160.
Page 160.
Yes. Para 2. The grievance of the petitioners is that while NHM has engaged allopathic and Ayurvedic doctors under NHM on contract basis, the fixed pay given to allopathic doctor is
Where are you reading paragraph?
Para 2 of page, at page 160 minute. The grievance of the petitioner is that while NHM has engaged allopathic and Ayurvedic doctors under NHM on contract basis, the fixed pay given to allopathic doctor is higher than that given to the Ayurvedic doctors. This is our grievance till now. Now please come to me, Lord, page number 166, 7. The operative portion of the order, of which we would like to take advantage of. Para 15. A perusal of the order of the division bench of the Uttarakhand High Court passed in WPC number so-and-so, and order dated passed by the Apex Court in special leave appeal number so-and-so show that Ayurvedic doctors would have to be treated at par with allopathic medical officers and dental medical officers under NHM, and as such, there cannot be any discrimination in the payment of salary wages between the two. This is further fortified by the fact that the state respondents have taken a conscious decision to give the same scale of pay to the Ayurvedic doctors and allopathic doctors working in the health department under the government of Assam. In view of the reasons stated above, respondents are directed to pay and release.
That's all right. So government has taken a decision.
Lord.
The court relies on the government decision.
Now government has implemented the order in the next page. Page 168. This was challenged before the learned single judge, my lord.
Just.
Yes.
Page 168.
Yes.
Yes. What does it say?
In pursuance of the Honorable Guwahati High Court order in WPC so-and-so and subsequent approval from the government of Assam, the initial remuneration of the medical officer Ayur, doctor engaged under NHM, is hereby revised as follows. Now kindly see, my lord, revised initial remuneration would be, earlier it was 30,500. Now it would be 40,000 per month with effect from 18/12/2018 to 31/3/2019, and 50,000 per month with effect from 1st of April 2019. Well, this has created an anomalous situation because my juniors would get more, will get less. Now, all that we want is, my lord, this judgment has attained finality. There is no appeal against that order. That should be implemented.
No, but how does it adversely affect you?
It affects us, my lord.
How?
Yes, I'll show. Now, please come to, my lord, page 170.
170.
Yes. He is one medical officer MBBS. Now he is getting 78,500.
He is getting
78,500 in the month of May, June 2020. Kindly come to next page, my lord. In August, September, he is getting 90,890.
So you challenge this execution
Yes,
part.
now my lords come to our part. I have shown the examples. Then please come to my lord, page number 190.
So we definitely fix
190, my lord, Rafiqul Islam, he is an Ayurvedic one. Kindly see, he was getting in April, May, my lord, only 45,525.
Therefore,
So, my lord, there has to be some uniformity.
that's right.
With
So
effect from
where is-
18/12/2018.
no. So where was the question of your filing an appeal?
No,
Let's see.
My filing an appeal because my writ petition was dismissed.
Where is that
Yes,
dismissal?
yes. The impugned judgment is at page 207, my lord. And lordship will kindly come to 211.
207.
Please come to page 211. Para 8, I have heard the learned counsel for the parties and given my anxious consideration to the matter. From the judgment passed by the Supreme Court in case of P.A. Bhatt, wherein it was categorically observed that Ayurvedic doctors and allopathic doctors discharge diverse function and are not performing equal work, and as such would not be entitled to equal pay. The issue therefore pertaining to grants of pay on principle of equal pay for equal work therefore stands concluded in view of the judgment of the Supreme Court in so and so. As regards the contention relating to the challenge to the order dated 21/10/22, where the benefits of the revised structure has been given only to cases where drawing lesser remuneration per month and taking into account the submission of B. Gugoi and the counsel for NHM, that the said was done in order to protect those medical officers Ayurvedic so that who do not get lesser amount than what has been revised by this court. Therefore is of the opinion that the question of interference with order dated is not called for. Be that as it may, this court is also of the opinion that if the member of the petition association is only getting benefit in terms of the order dated 21/10/22, member of the association would be at liberty to file representation before respondent number 2, who shall, taking into account the order dated 21/10/22, grant benefits as given thereunder. Now, my lord, P.A. Bhatt.
One second. Let us see the communication which was challenged by you.
Yes, my lord.
Communication.
Page 168.
No, I don't understand, Mr. Gogoi. What this communication is by virtue of the judgment passed by Justice Michael Zothanko. Right.
Lordship.
So you say that 50,000 per month, it is at par.
Yes.
You don't say at par, you just increase their.
No, that is the my lord, minimum my lord, remuneration that were at that time allotted to the my lord, Ayurvedic doctor, allopathic doctor. So it has been enhanced my lord to 50,000.
That's all right. So thereafter, how do you?
It is continuing my lord.
No, and minimum was that. So do you have a pay structure, pay band or something?
No, my lord,
It's a
they are all
contractual
contractual employees, my lord.
No, so but how come this allopathy doctor was getting 78?
No,
90,000.
My lord, there are certain increments which are added, my lord. That amount they are showing, my lord, in the annexures, right from my lord page.
And those
170.
Just a minute, those increments are not available to the Ayush doctors.
No, increment will be available provided, my lord, they are brought into the same category person with a court's order. Thereafter, they will get it, my lord. This is the grievance that, my lord, on that very day, they should be given that particular scale or remuneration.
But you are absolutely just, Mr. Chaudhary.
That's why we say it, my lord.
How can you claim that?
My lord, what does equal?
No, it says,
Yeah.
see, at the time of initial appointment,
Yes.
the remuneration of an allopathic doctor was 50,000. You were getting 35,500.
Yes.
That was raised to 50,000.
Yes.
In fact, allopathic doctors also were getting 40,000 It was
Well,
increased.
am I to understand
Just a
that
minute, just-
Ayurvedic doctors are not entitled to increment and other benefits?
We are not saying that.
But that they're meaning that, my lord.
No. Just a minute. Please hold on for a minute.
Yes.
So pursuant to that judgment of Uttarakhand and of our High Court, this order was passed. It was not challenged. Finality, all right. So the judgment was only with respect to equal salary, parity of pay.
Right.
Parity of pay is decided by the entry pay.
Certainly.
And
No,
increments.
in fact, this honorable court fixed a date of approaching, that is 18/12/18.
That is all right. 18,
If
12,
if your lordship would kindly come to page 167.
1 second. Now
Yes.
forget about that cutoff date. That you're not questioning that cutoff date should have been from the period
No,
that they were
no,
taken.
no.
You're not claiming that, so let us not discuss it. And that cutoff date also, after what is that Goel's case, now that discretion is with the government,
Yes, sir.
financial
PA Bhatt.
viability. So that you're not questioning fortunately.
No.
But question is this, they are not stopping any increment to you. The examples that you've given are only because of the addition of increments,
Yes.
which you'll also get over a period of time.
No, I'm not getting, my lord. That's why I'm saying.
So
If they assure that they will give the increment, very well.
Sir, then.
Yes, let my learned friend say
difficult
that.
thing is that you created problem for yourself.
I
with
have
this
not
single-
created, my lord.
No, you have created problem for yourself by challenging that communication. Where was it written that you will not get increment?
No, my
And you
lord,
challenged the communication and then the single judge
No, my lord,
decided it
we were-
PA Bhatt and this is complete overhaul. Now, by virtue of PA Bhatt and this judgment, in fact, they can even reduce it
No,
now.
my lord. PA Bhatt is regarding the age of superannuation.
Now-
On pay parity, there are three Supreme Court judgments have brought all the judgments.
No, therefore, this should have been questioned that you can't possibly do that. PA Bhatt, you can't apply PA Bhatt. You say that.
Yes, of course, I'll say.
So therefore, it is on that issue. Forget about execution.
No, anyway,
part.
that is okay. All that we are saying is,
Just-
while implementing the order of this honorable court, they have committed an error by not giving us equal pay.
क्या कहते हैं? You're only getting benefit in terms of the order, the members. They have not stopped it. I think you are over conscious of your rights. What fruits you had got out of litigation, you wanted it to be
No,
spoken.
no, my lord, kindly see the first para.
Where is your
Existing,
statement that you are not getting any increment? Unlike unlike allopathy doctors.
yes, it is there. I'll show, my lord. Because I was not before the learned single, I'll show, it is there.
So with respect to age, all right, PA Bhatt. Then you question that then don't press it.
One second, my lord. Judgment in the repetition from court.
My lord, regarding
thing.
PA,
Do one thing, if we specify, then perhaps we'll have to go by Supreme Court judgment.
Yes.
Not Michael's judgment. They would be perfectly entitled
yes.
in view of the judgment to even reduce the salary.
No, my lord, they have, no, if that is their intention,
Now-
let them, my learned friend say.
Now, the question is this. They say that you can't enforce parity because the function of a doctor, Ayurvedic doctor and allopathic doctor are different. You might counter it by saying that both of them treat patients with
Patient.
medicines and they are under contractual employment. That's all.
Both are contractual.
That's right. So therefore, it is, the function is not diverse. Therefore, there should be pay parity. But where was the occasion for you to get all this observation from a later single judge judgment? No occasion had arisen.
No, there is occasion, my lord. Because, no, kindly come to one sentence.
Now,
my lord.
therefore, don't press this PA Bhatt and this judgment. You follow what the single judge says, go before them, ask them whether you are giving us increments or not. Don't question it now. Otherwise, we'll say, we will read PA Bhatt. If it says that the function is diverse, we will leave it open. It is for them to withdraw
No, my
your
lord,
side.
that will create again a problem. Why I'm saying so, my lord? Thus will kindly have the judgment for a moment. I can pick this up. I don't know.
Your clients.
No, my lord, I'm
have
just trying
assumed
to.
a hornet's nest.
No, my lord, that is one problem. That's why I'm saying that, my lord. In this compilation, my lord,
No, let us see PA Bhatt first.
Yes.
PA Bhatt, ऐसे तो ऐसे. No, PA Bhatt I have also given. My lord will first come to page number 1, my lord.
Of the compilation.
Yes, page number 6. Para 23.
This is not Delhi Municipal Corporation, yes.
The common contention of the appellant before us is that classification of Ayush doctors and doctors under Central Health Services in different categories is reasonable and permissible in law. This, however, does not appeal to us, and we are inclined to agree with the finding of the tribunal and Delhi High Court that classification is discriminatory and unreasonable since doctors under both segments are performing the same function by treating and healing their patient. The only difference is that the Ayush doctors are using indigenous system of medicine like Ayurveda, Unani, etc. And CHS doctors are using allopathy for tending to their patient. In our understanding, mode of treatment by itself under the prevalent scheme of things does not qualify as an intelligible differential. Therefore, such unreasonable classification based on it would surely be inconsistent with Article so and so.
Agreed.
So method of treatment is not.
So the government has agreed.
Yes.
The government gave you.
Yes.
That initial salary parity.
Yes.
But where is the question of, making comparison with somebody whose pay slip you have annexed is because of the enhancement, is because of the increment?
Milord, may I make one submission, Milord? Let my learned friend also take the instruction. I'll also take the instruction, Milord. Let the matter come up on 15. On that increment part.
One minor submission. So far as the minor learned single judge's order, minor, which is impugned herein, the liberty has been given to the individual members of the association to approach the authority if they have any individual grievance. Some is getting, some is not getting. That person can approach, my lord. There is a liberty given finally. They have not approached, my lord, directly, my lord, rejected.
No, my lord.
Possible see that, my lord. Everything
You
was
just take
considered.
instructions
Yes.
with respect to this.
Hmm.
And you might even, your department might even think of, coming out with another notification with PA Bhatt.
Yeah, but this, my lord, directly is, my lord, this issue was considered. Whether, my lord, Ayurvedic doctors and allopathic doctors will get the
Diverse
same.
functions, therefore.
That's why, my lord, in fact.
Not only
category
PA,
they
there are 3 other judgments of the Supreme Court in the same compilation. I have
You
given.
will choose that judgment, what to do?
No, this is the latest one, my lord.
The
PA
government-
is the latest.
No, my lord.
Do one thing.
Initially,
Mr.
based
Mr.
on the
Chaudhary,
method of treatment.
Mr. Chaudhary, don't give an opportunity to Mr. Gogoi to reconsider all this.
No, my lord, our grievance is senior members will get less, juniors would get higher. That is the problem, my lord.
No, so therefore you have to represent. Go and represent before the authorities. Don't create further confusion. Otherwise, we will say, once the issue is decided that their functions are diverse, though they may be treating patients, in that case, the earlier part of the orders, earlier things also go.
No, my lord. As far as the order of the Honorable Justice
When you
Michael
have heard-
Duthang Kumar is concerned,
No, when you have
unless
heard-
they appeal against that order, they cannot take that stand.
That's right.
Yes.
So now
They have not done.
they can take a stand on the basis of a judgment of the Supreme Court.
No, my lord.
Uh,
If I have correctly understood the judgment of the Supreme Court, that individual judgment has, there are cases
Anyway,
where
now-
from ex-judgment, Supreme Court
But
Court
why
interferes.
do you want to do that if all liberty has been given to you? You go and tell them that, are you giving us increments like Ayurvedic, like allopathic doctors or not?
That I'll do, my lord. Let the matter come up on 15, my lord. Let me also have the instruction of the clients, my lord.
When he has made a statement, I don't think he would have made a casual statement that you are also getting the same benefits. This parity is because of some payslip of some doctor who is getting more. I think I'll be getting more than my brother.
Naturally.
So therefore, he can't question the government that why are you giving him more.
My lord, because of less number of service, if I get less, that is okay.
That's okay. That's what he's saying. If he has not recalled this, then you are getting the same thing. Unless they say, and this execution part, the order, executive order, which you showed to us.
Yes, page 168.
Where does it say that you will? It is they have only fixed a date.
No, my lord, there's a catch. Kindly see. That's what I'm saying, my lord. So please come to 168 for a moment. Last sentence in case of second para. In case of drawing lesser remuneration per month.
No. Just read the second part. The yearly increments released during the corresponding periods by orders issued from time to time shall also be taken into consideration with revised initial remuneration or the remuneration known, whichever is higher.
Whichever is higher.
So therefore, they are not stopping the increment. So first, suppose you would have earned the increment, making your salary to be 50,000 without this. On 1/4/2019, perhaps it would have been taken into account. You would not have got, you would have got only 50,000. Because this is taken as the first entry point of 50,000 scale. Right. Thereafter, whatever increments you earn, they are not prescribing it. This is how I understand, we understand. And subject to, I mean, that is also understanding has been based on his disclosure. Whether you would you like to press this?
And my lord, on individual representation, we'll be passing speaking orders. He can always come.
Mr. Gogoi is contemplating how to reduce your salary now. Belated, they will file, they can file an LPA.
Lord, let it come tomorrow.
Yes. All right, we are not snatching any
Yes.
concession
No,
from
Lord,
you today.
Because these are all association people,
That's-
hundreds of
that's
people.
right.
that are waiting
And therefore,
to be-
therefore, the courts were absolutely with you. The government also is not against you. The government is not against you. How can they ignore Ayush? When they are
No,
distributing.
they have been ignoring all throughout, Miller. That's why we're getting only 35 when others were getting 50.
That's all right. Now they have changed.
Then let the matter be called tomorrow, Miller. Let us have some instruction.
Has prayed for re-notify also.
Tomorrow.
Tomorrow. There's some problem in listing. Tomorrow, how many matters? Such it's a hearing day, no? All right, tomorrow. Mr. Gogoi, make yourself available in that.
I'll bring him in while coming to the court.
Three matters? Chalo, chalo. 35, 36, 36. Criminal appeal from the second half.
Item 35 and 36.
Yes, no. Yes. Who appears for the other side?
My lord, the government council and the finance department, my lord.
Gogoi.
Ideally should be, my lord.
Call him. Call him and we are coming back after 5 minutes.
My lord.
Ask him to be here.
My lord.
Oh, he should, Advocate General or him or Sharma or Bora should be here. Huh? We come back after 10 minutes. Just inform Mr. Gogoi.
My lord.
This is with respect to the cutoff dates.
The revision of pay rules, my lord, 2017.
Cutoff dates.
My lord.
Yes.
My lord.
This is item number 35.
I
beg sincere apology for being late, my lord.
Doesn't matter. The list got exhausted. We don't know how.
My lord. My lord, the issue in the writ petition, my lord, is regarding the date of implementation of the ROP rules of 2017. That, my lord, starts at page 87. Page 87, my lord.
Yes.
Page 87. Notification. Dated so and so, 17th of March 2017. My lord, application of the rules. Application of the rules 2B. Unless specifically extended under express order of the government, these rules shall not apply to the Roman italics 1, 2, 3, 4, 5, 6, 7, 8. My lord will kindly come to Roman italic number 9, my lord. The government employees who have retired in the afternoon of the 31st of March 2016. It ideally ought to have read as government employees who have retired on or before 1/4/2016, my lord. 31st of March 2016 is the cutoff date. Now, my lord will kindly come to page 88. Page 88, my lord, the last point. 5. Application of the revised pay.
Yeah.
Yes, my lord. Now, save as otherwise provided in these rules, a government employee who was in service on 31st of March 2016 or who may have been appointed on or after 1st of April 2016 shall draw pay in the revised pay structure within bracket pay band with grade pay, bracket close, applicable to the post service which he has been holding or to which he may have been appointed as the case may be, provided the government employee who is in service on 31st of March 2016 or who enters service on or after 1st of April 2016, but before the date of publication of these rules may at his option continue to draw pay in the existing pay structure until the date on which he earns his next or any subsequent increment in the existing pay structure or until he vacates his post or ceases to draw pay in the existing pay structure. Now, the ROP rules, my lord, they come into effect from the 1st of April 2016. Now, our case, my lord, is based on the pattern which was adopted by the government on prior implementation of the revision of pay rules. In this regard, my lord, will kindly come to Annexure 1, which starts at page 20. This is an APPC report, my lord, the Assam Public Pay Commission report, which preceded the ROP rules, my lord. It starts at page 20. Starts at page 20.
Yes.
It starts at page 20, my lord. There is a background of the issue. Now I'll beg your lordship's attention at page 67. Financial implications, page 67. Date of effect. The issue relating to the date of effect of the recommendations of the Commission was discussed in the last full meeting of the Commission held on 4th of October 2016. A question was raised whether the terms of reference of the Commission mandates it to specify the date of effect. It was clarified that the government notification dated 2nd of June 2015 does not include any such term of reference, while the terms of reference of the 7th Central Pay Commission included specifically the term to recommend the date of effect of its recommendation. In view of this position, it was felt that the Commission carefully considered this issue. The terms of reference of the earlier commissions/committees set up by the state government were examined, and it was found that none of these included any such term of reference. In spite of this, all the pay commission committees have suggested the date of effect in their recommendation. The position in this matter is below. Your lordship sees a table, my lord. From 1964 onwards, my lord, 1973 onwards, to be precise, all the revisions of pay have taken effect from January of that particular year, my lord. 1st of January 1973, 1st of January 1981, 1st of January 1980. My lord. Yes, my lord. Now, my lord. The last paragraph, rather, my lord. The Commission felt that the practice followed by the previous commissions should be honored and a date of effect should be recommended. While making the recommendations regarding the date of effect, the APC 1972 recorded in para 1.4 of chapter 1 as follows. Now, all of these pay commissions, my lord, the revision of pay, that those particular extracts has been detailed, my lord. And the dates have been fixed at 1/1 of that particular year. Now, my lord, will kindly come to page 68. Italics, my lord, Roman number 8. The employees demand 1/1/2016 as the date of effect, which implies a revision after 8.25 years. In the light of the above discussion and the prevailing resource position of the state, the Commission is of the view that a 10-year gap be maintained between present and the last date of effect, that is 1/10/2007. The retrospectivity of the date of effect should not be encouraged as the resources cannot be generated retrospectively. Practice followed by Central Pay Commission, who always recommend for a prospective date of the effect of the guideline. And number D, my lord, which has been assailed. Date of effect should be shifted to 1st of April instead of 1st of January for better financial management and avoid liabilities of previous year being carried to the next year.
That's right. That's the reason. You have read out the reasons.
My lord, now our basic fact, my lord, if your lordship may kindly also come.
And if you could read a
My lord.
paragraph before,
My lord,
I think if you come to page 68,
68, my lord,
this is Roman 7.
Roman 7.
Just read that.
Yes, madam. It is seen that till 1996, the pay revision was done at an interval of 8 years. And in fact, the revision of 1996 was done after 7 years. Thereafter, 10-year cycle has been followed, leading to the revision in 2006. Government of India changed to a 10 years revision cycle from 1/1/1986. But in case of the state government employees, the revision in 1989 and 1996 was still done at the interval of 8 and 7 years. If the 10-year cycle would have started from 1989, the revision would have been due in 1999, 2009, and 2019. The APC 2008 recommended that the revised pay structure be effective from 1/4/2009, but added further that the revised pay for the employee shall be notionally fixed as on 1/1/2006. They further clarified that no arrears would be paid for the period between 1/1/2006 to 31/3/2009. Though the recommendation of the APC 2008 apparently followed a correction course, the state government subsequently agreed to pay the revised salaries with effect from 1/10/2007. Now, my lord has rightly pointed out.
Therefore, the last of the D says,
Yes, my lord.
the date of effect should be shifted to 1st of April instead of 1st of January for better financial management and avoid liabilities of previous year being carried to the next year.
My lord.
So this is the reason.
My lord, what had happened, as the lordship had rightly pointed out, the effect of the earlier revision of pay, that order revision of pay, my lord, was interfered by this honorable court, in fact. In fact, my lord, there is an order that your lordship had passed very recently, where there was a challenge made. What had happened in that revision of pay was that the revision of pay was sought to take effect, not from 1/4/2009, my lord. It was sought to take effect from 1/1/2009. But there was a categorization made for retirees who have retired pursuant to that date, that people who have retired after April 2009 will get the arrears. And people who have retired prior
That
to
also we affirm that.
Your lordship had
We affirm that classification
My
on
lord.
the basis of Goel, which Goel's case.
My lord, All Manipur Pensioners Association, my lord, which had reaffirmed DS Nakara. In fact, what had happened, my lord, that the state had sought to create two different classes amongst
That's different, but your case is different.
My lord, it's a policy decision, my lord. I'm on very thin ice here, but
That distinction may have been different, but yet this is fixing a date.
Fixing a date, my lord. It's a policy decision, my lord. Your lordship will grant.
There is no distinction between one class of.
Absolutely, absolutely. Your lordship is very right. In fact, the reliance which was placed by the state government on the earlier APC, my lord, the revision of pay, that might not be correct in the scheme of things in this writ petition, because here, my lord, we are just seeking for a correction of the date, which ought to have taken.
Alteration, not correction.
Alteration, my lord. Alteration. my lord.
Alteration, you think the judges should do it?
My lord, again,
unless it is arbitrary, perverse.
My grounds are, my lord, very limited grounds, my lord. The first ground that I'll take, my lord, before I take your lordship to that ground, which is legitimate expectations, my lord, because I've taken your lordship through page 68, in fact, page 67, which goes on to show the notional date of effect of the recommendation of those prior revision of pay.
Can I have a name, please? You're arguing very well. What's your name?
M. Sharma, Maharshi Sharma, my lord.
Mr. Sharma, legitimate expectation ground
My lord.
cannot override,
My lord.
either statutory prescriptions
True, my lord.
or government
True, my lord.
government decisions.
True, my lord.
That's true. I mean,
my lord.
everybody expects to be employed.
True, my lord.
Everybody expects to get apex scale.
True, my lord.
There is legitimate expectation may not be legitimate, but legitimate expectation, but financial stringency, financial comfort of the state,
My lord.
viability,
My lord.
subject to pecuniary viability.
My lord.
That is an important consideration which cannot be set aside. We can't question that. We can question that, but we would be loath in entering into that field. So this, of course, because you retired on the last day or maybe before that, prior to that, so you are left, and that somewhere there has to be a classification, no?
Somewhere.
So it fell on 1st of April.
My lord.
And this April thing is being followed world over and in all departments. So for ROP rules for the last several years, about 2 decades, it was in January.
My lord.
But they say that January thing doesn't know because the fiscal years are calculated on the basis of April.
True, my lord.
And that's how you pay your taxes also.
Yes, my lord. But your lordship is very correct. In fact, we might not have a lot of leverage, my lord, in this matter, since it pertains to fixing of a date and which is a policy decision.
And that's the only thing.
That's the only thing, my lord. So in fact, what had happened is there's an anomaly report also, which came to be notified, my lord.
And the anomaly report also affirmed that this is the correct date.
The anomaly report reaffirms the date by being completely silent on our nature of demands. That is the problem that I just tried to seek before your lordship, my lord. My lord will kindly come to page 79. 79. 79, chapter 2.
Yes.
My lord. Chapter 2, my lord, findings and recommendations of the committee. It starts from heading 2.1, findings, my lord. My lord will kindly come to page 80, which is the next page. 2.3, nature of demands. Altogether, 225 associations have submitted more than 500 demands of various categories. The committee took up all these demands for deliberation, department-wise. The committee, during the progress of deliberation, observed that the associations have submitted their demands in the same manner as they have submitted before the pay commission. That is, limitations of an anomaly committee were not visualized. On the whole, the nature of the demands received can be broadly divided into the following four categories. Fresh demands having no relevance to the recommendations of the 7th APPPC, which are summarily regretted by the committee as consideration of fresh recommendation is not the mandate of the committee. In some cases, more grade pay is claimed with reference to the recommendations made already by the 7th APPPC. As no anomalies have been detected, these cases are left to be examined by the... There is no whisper of... There absolutely no whisper. Now, my lord will kindly come to page 82. Page 82, after taking care of the demands which have been set forth and categorized by the government in page 80, 2.5.10, date of effect, my lord, page 82.
They write it here. They did not classify it at
They
one
did not,
place,
they did not classify it.
but they have
But,
focused it.
yes, my lord, and they found no justification to enter with it, to interfere with the date, and has summarily, without according a reason thereof, my lord. Now, our claims, my lord, might not have much judicial weightage in the sense that it's a policy decision.
After DS Nagara, Mr. Sharma,
My lord.
show me one case where it has been interfered. After DS Nagara talks about some other things.
In fact, yes, my lord.
It's about pensioners in detail.
Pensioners in details.
But
Well,
after Sharma, after Nakara, I don't think you'll find any judgment.
in fact, my lord, I have
Homogeneous class, that was the judgment, that's all.
yes,
And it's all started from there.
my lord.
Government has wide discretion.
True, my lord. True. In fact, DS Nakara.
And the moment they say that because of the financial comfort situation, if they do it,
They do it, my lord. That's what they have done, my lord.
they close the gate in our faces.
And we happen to be the first instance of the gate being closed on our face. In the past 50 years, my lord, starting from 1970. This had happened for the first time. It was not the first time. It is not the case of the state, my lord.
The reasons, therefore, I asked you,
My lord.
show me one instance after Nakara
My
where
lord.
this was questioned.
My lord, I've submitted a copy of, my lord, All Manipur Pensioners Association, my lord, which may touch on the issue subject to your lordship's final consideration, my lord. My lord, paragraph number 8, which starts at page 637, my lord. And All Manipur's Pensioners Association, my lord, takes care of DS Nakara as well. And
Page 8, paragraph 8.
paragraph 8, my lord, page 637. Amarnath Goel was also considered, my lord, which goes to maybe the root of the issue, my lord. Amarnath Goel was considered, and DS Nakara was considered, PN Menon was considered. Paragraph number 8, my lord. Even otherwise on merits also, we are of the firm opinion that there is no valid justification to create two classes, viz. One who retired pre-1996 and one who retired post-1996 for the purpose of grant of revised pension. In our view, such a classification has no nexus with the object and purpose of grant of benefit of revised pension. All the pensioners form one class who are entitled to pension as per the pension rules. Article 14 of the Constitution of India ensures to all equality before law and equal protection of laws. At this juncture, it is also necessary to examine the concept of a valid classification. A valid classification is truly a valid discrimination. It is true that Article 16 of the Constitution of India permits a valid classification. However, a valid classification must be based on a just objective. The result to be achieved by the just objective presupposes the choice of some for differential consideration / treatment over others. A classification to be valid must necessarily satisfy two tests. Firstly, the distinguishing rationale has to be based on a just objective. And secondly, the choice of differentiating one set of persons from another must have a reasonable nexus to the objective sought to be achieved. The test for a valid classification may be summarized as a distinction based on a classification founded on an intelligible differential, which has a rational relationship with the object sought to be achieved. Then, my lord, there's another judgment on.
Just a minute.
My lord.
Where has it taken note of Goyal?
My lord, if your lordship may kindly come to page 637 itself, my lord. 7.9. Paragraph 7.9. Just above, my lord. Your lordship would see the division bench 7.9, my lord. Hariram Gupta, Veerasamy, Amarnath Goyal, P.N. Menon, and Amritlal Gandhi. But it is my duty to point out, my lord, Amarnath Goyal was slightly on a different footing, my lord. Because Amarnath Goyal pertained to an issue similar in this petition, where there was a cutoff date. And
And here, what was the issue? Why this classification?
My lord, here it was categorization of pensioners, my lord.
One who retired pre-1996.
Yes, my lord.
And those
One who have already retired. So there, what the government ought to do.
Suppose instead of saying pre and post, they would have fixed a cutoff date.
My lord, that was what was done in DS Nakara. In DS Nakara, the government looked back and said, we'll create two classes. In Amarnath Goyal, the government said,
Amarnath Goyal this is grant of pension.
My lord, this should be.
That is revision of pay.
True, my lord. True.
So
That's
therefore,
my duty
these
to point
two
out. My lord.
principles cannot be conflicted.
My lord, that was my duty to point it out such side because.
Otherwise, Supreme Court would not have come with this judgment.
My lord.
This is create for pension.
My lord.
All pensioners. And the rationale was cost of living. So that would apply effectively to all.
In fact,
so therefore, in that context, this Manipur's case is all right.
In my submission as an officer of the court, my lord, Amarnath Goyal would be applicable in this case. My lord, just one more judgment, my lord. One more judgment, my lord.
It's so heartening to see that a lawyer who is arguing against a judgment is always reminding the court, yes, I am arguing, but this is the judgment. It's very good. I appreciate that.
My lord, there's another judgment, my lord. 2006 8 SCC 399, my lord. Just a limited scope on legitimate expectations, my lord. Paragraph 33.
Legitimate expectation.
My lord.
Legitimate expectation, I think case Puttaswamy, 2 paragraphs about legitimate expectation that sums up everything.
Yes, my lord. That you're not bound to act judicially, but you're bound to act fairly. And being fair, my lord, in my humble submission, in the past 5 decades, my lord, I was the first one to have had a cutoff date, which was stretched to a month in April, which had denied me the benefits which I otherwise would have accrued to me.
Today, we were looking at some of the provisions of Surrogacy Act.
My lord.
And while the first process of surrogacy had started,
my lord,
and it continued, but it failed. And then the amendment came, the amendment had the effect of preventing that particular couple in going for surrogacy because of that certification regarding age.
My lord, yes.
So she was at the coal face that time. It happens, no?
These are all dates, my lord.
It all happens in all branches,
my lord.
Wherever you go, in all branches.
True, my lord. True. No, that is my limited leg of my submission. That the effect should have ideally come from 1-1 and not.
Anyway, you show the legitimate expectation
my lord.
Here.
Paragraph number 33, my lord.
For us to note it down in our judgment.
Yes, my lord.
The efforts you have made, it must get reflected. Mr. Borpujari, is it correct or not? Yes.
Paragraph number 33, my lord. Page 416. Your lordship is there, man? Yes.
Legitimate expectation is the latest recruit to a long list of concepts fashioned by the courts for review of administrative actions.
No doubt the doctrine has an important place in the development of administrative law and particularly law relating to judicial review. Under the said doctrine, a person may have a reasonable or legitimate expectation of being treated in a certain way by an administrative authority, even though he has no right in law to receive the benefit. In such a situation, if a decision is taken by an administrative authority adversely affecting his interest, he may have justifiable grievance in the light of the fact of continuous receipt of the benefit, legitimate expectation to receive the benefit or privilege which he has enjoyed all throughout. Such expectation may arise either from an express promise or from consistent practice, my lord, which the applicant may reasonably expect to continue. My lord, that is my limited legma. And paragraph 34, my lord. The expression legitimate expectation appears to have been originated by Lord Denning.
Oh, that's right, but read paragraph 35.
35.
That may give us some clue.
My lord. In such cases, therefore, the court may not insist on an administrative authority to act judicially, but may still insist it to act fairly. The doctrine is based on the principle that good administration demands observance of reasonableness, and where it has adopted a particular practice for a long time, even in the absence of a provision of law, it should adhere to such practice without depriving its citizens of the
Whether
benefit.
this is justiciable, whether a mandamus could be issued on this. And then see the ROP rules, acceptance with the government, anomaly report.
The anomaly report followed the publication of the rules, my lord.
That's right. That's right. So they did not find any flaw.
But that is fine.
They did not find any anomaly.
they could not-
Why should there be interferences? They don't find anything.
They
bad.
could not find an anomaly because they did not address my grievance in the first place.
You're right. With ROP, if you can show any judgment where the date has been tinkered.
No, my lord. There has not been tinker. Amarnath Goel is a landmark judgment.
Even if we do,
My lord.
I mean, persuaded by your very good argument, even if we do, this will not stand the scrutiny of Supreme Court.
My lord. My lord. That is based on where I stand.
Why are you laughing, Mr. Pujari?
No, my lord. He has made a brilliant effort, my lord. I owe to him.
My lord. These are my limited submissions.
We have heard so and so. Somebody will come. Come to my chamber, we'll dictate it after lunch. We have heard Sri Swanswan and Sri Swanso. The petition is dismissed.
Item 37.
I'm so obliged.
Item 37 is what?
Yes, Lordship. Lordship, may I have Lordship? What's the matter pertaining promotional benefit? Lordship?
You argue after lunch?
Yes, Lordship.
उसको हमारे पास दे देना।
Yes.
हाँ ठीक है उसके साथ पढ़ो ये जो अभी जो हमने then we'll go वो अभी हमारे चेम्बर में होते
Yes.
all right
Item 37.
yes
The matter pertaining a promotional benefit. So the evidence for that was working as a subsequently promoted holder. So in the year of 1994, he was terminated due to the shortage of the immunity. So the same year, he has reached the doctor. Kindly find the page 45. Then document dated page 9 of the page.
page 45
Yes, page 45.
yes
Mary.
yes
The applicant at the relevant time was serving as a holder at the 16th Assam Battalion Constitution.
where are you reading page 45
The second paragraph, the petitioner at the relevant time.
yeah this is your quoting your reading from which judgment
Yes. It has just been now honorable Justice B. because the coordinate can initiate.
no I mean what was the issue before the court
So, Your Lordship, my father service has been set off. So after terminate.
after termination your services were reinstated
Reinstated.
Huh.
So, Lordship, concerning the Lordship, that during the time of it, there are another 6 person was terminated. 6 personnel. So they have already promoted and until the benefit. So my question is that Lordship, so the similar period person, they have entitled the promotional benefit. So why not the appealant for the law?
Just a minute, give us 1 minute.
Yes, sir.
Public access. केवल रूल क्या होता है, केवल रूल नंबर Rank of constable could be no fact really होगा बड़ा मुश्किल है. No, pero 14 is not. That will matter. The relief is paid for in the present proceeding by any original statement not returned. This court is review effect the system the matter. Give us the timelines. Louder, sir. Either you speak on the mic, you have to shift a bit this side or that side where you can, your voice will catch the speaker. I mean, the speaker would catch your voice.
Lordship, we do respect Lordship. So Lordship, threshold the one aspect Lordship is a relevant part of the page number 46, the bottom portion of the 5 line Lordship can define Lordship.
No, just a minute.
Page 46.
Just a minute. Before that, let me ask Mr. Sharma for the state. Now, what does the single judge say in paragraph 14? We are not able to understand that. You're defending this paragraph 14.
Yes, my lordship, may kindly see the earlier order dated 18/8/2009 is a page, my lord. 69.
Yes, sir.
See, the appellant, I mean, we are referring, appellant now is the son of the employee,
My,
but we are referring to him as appellant.
yes.
Forget about that. That was permitted. It will be easier. Every
Yes.
time saying that father of the employee, son of the employee. Now, he retired on 36/2009.
Right.
Correct? Before that, no, only after that. The penalty was set aside by judgment dated 18/8/2009.
My,
So this was 2 months after,
my,
maybe less than 2 months after. Right?
my,
So this clean record now,
my,
can it be used retrospectively for an empanelment list for promotion which could not be effected at that time for the reason that there was a criminal case pending and there was a departmental proceeding pending? All right. So he was not appointed then.
Right.
He was not promoted to that post.
Sub-
So therefore, when he says that that was wrong, everything has been set aside. Then
subsequent-
why not from that date?
My lord,
Now, the logic perhaps is after recording everything in sequence, the court says this, paragraph 14.
Paragraph 14, with reference to the earlier judgment of 18/8/2009. My lord, lordship may kindly see, it start at page 69, the earlier judgment.
Page?
Page 69. And the relevant section which I would like to point out, my lord, page 74, second paragraph.
Page 74.
74, second paragraph. Because the punishment subsequently imposed upon him, that was not under
You-
salary.
Page 74,
Page 74, paragraph, second paragraph, my lord.
having heard, it starts from
Having regard to.
having heard the learned counsel.
Not like the learned
Yes, read that.
Having learned the learned counsel both the parties and careful perusal of the materials placed before this court, it is found that the order dated 1/5/2005 passed by the disciplinary authority imposing punishment of stoppage of increment and recording of two black marks was not challenged by the petitioner before the appropriate authority and thus accepted and state punishment. Therefore, the state order of punishment dated 1/8/2018. The petitioner is apparently agreed by the order dated 13/6/2008 passed by the review authority. It is the petitioner case that the review order imposing the higher penalty. That was, my lord, set aside.
That's all right. So that was set aside. No, therefore, we can see that ground there.
My-
See, paragraph 14 becomes intelligible only when you read this. Correct?
My-
So when you read this, then it appears that the stoppage of, two increments and
Yes,
black mark,
my-
that remained.
my-
That remained.
Yes.
Now, in that case, you retired without promotion. And that even the empanelment for promotion, it made it very clear that it would be subject to departmental proceeding, criminal case or other things. So therefore, the court was justified.
So, Lordship, with due respect, Lordship, the initial proceedings has set aside, Lordship, and that.
We have followed. Initial proceedings set aside. You came to the court 5 times.
But subsequently, Lordship, the.
Subsequently, when the punishment of stoppage of 2 increments and black mark was given to you,
Yes.
you did not challenge it. Now we are only
Yes, Lordship,
giving
yes.
you the fact on which we can decide. Now you never challenged it,
Yes, Lordship.
right?
Yes,
And
true.
this was given after you retired.
Yes,
This judgment was given after you retired.
yes, Lordship.
So therefore it reverted back. And this the judgment dated 18/8/2009 was, passed setting aside the order passed by the reviewing authority. It was a suo motu review. Against the minor punishment which was given to you, the authorities thought that because of the ammunitions missing, of which you were the in charge, therefore you should suffer a bigger penalty. But before enhancing the penalty, you were not noticed. It was on that ground that the review order was set aside.
Yes, Lordship.
Review order was set aside.
Yes.
But the original penalty of stoppage of 2 increments and a black mark remained on record. You never challenged it.
Yes, yes.
The question is that time you should have said before the court dated 18/8/2009 that it is not only review order, the earlier order was also being set aside.
But my grievance is.
Because that you could not have said. We realize this. You could not have said this because you never questioned it. It was only by virtue of the revised punishment that you approached the court.
Yes.
And you mentioned only the fact that you were not, since that penalty was accepted by you, but even then, this 2005 impanelment would have expired. Unfit to be.
But lenient remain easily expensive.
I don't think so. We can't Of course, we will have our own reasons for not giving you this
My
benefit.
grievance is, your lordship, concern is, your lordship, when the concerned department impose the punishment, lordship, there are the same, the 7 personal lordship, the same charges, lordship. So the another 6 person has promoted and entitled the all benefit, pensionary benefit or promotional benefit. So why not the father of the appeal, lordship? So this is my grievance, lordship.
What is your answer to this?
So
Limited question.
My lord,
He was tried along with 6 persons, or he was terminated along with 6 persons, invoking Article 311 sub clause 2 without any inquiry. That was said to say.
Yes, lordship.
But subsequently, they also, unless you say that he was convicted, the others were not convicted, criminal case would have been dropped against him after his death.
Yes, lordship.
my lord, that aspect of the matter has not brought by the petitioner, my lord.
Now, how many times will he bring?
Only, my lord, if my lord, the order of imposition.
No, only answer this.
Yes, my.
What has happened? Same set of persons,
Yes.
but they got their promotion while they were still in service. Is it correct? Those 6 persons got their promotion to
Yes.
the higher post from Havaldar while they were still in service.
Yes, lordship. Yes.
You retired.
Yes, lordship. They are the junior than me.
And when were they granted promotion? After your retirement.
No, lordship. Lordship promotion in the year 1998, lordship.
They got promotion in 1998.
Yes, lordship.
But why was he excluded from that consideration? Because his number was 56. There was no vacancy. Is that the case?
No, my lord,
Then-
because of the departmental procedure.
So others also were facing.
My lord, that is.
So, lordship.
No. These are the facts on which he has based his appeal.
Yes, lordship.
Now, we are not inclined to interfere with this judgment, but this has to be satisfied. You have to satisfy us on this.
That I have to take instruction on that. If
So,
my-
that is the only case,
My
no?
lord, if my lord, that is, will be taken into consideration, I have to take instruction from the department from that aspect. Why? They were promoted and he was. And in spite of my imposition of penalty, they were promoted. That aspect, I have to take instruction. You don't-
How long will you take to take instructions? See, his employee's son is here.
Yes, lordship.
Now, this is more than pensionary benefits. What the son is seeking is the resurrection of the dignity of his father.
Yes, lordship.
Therefore, we can't dismiss it without giving cogent reasons. And reasons we have, but then we must take in your explanation. Reasons we have, Mr. Das, we are not inclined to entertain your petition at this stage, but then we must give reasons for it.
Yes, lordship. Absolutely. Lordship, the Honorable Supreme Court held, lordship, is a.
Forget about Supreme Court, we are giving you that reason.
Yes, lordship.
But after the death, whether that empanelment for promotion would survive. But then he retired in 2009. Look at this, mister.
Well.
Even if that punishment of 2 black mark and 2 increments being taken away from him, the effect of that punishment would have expired on 1/8/2006.
Yes.
Right.
Yes.
And he retired 3 years later. Same set of persons you gave that promotion. He is asking for promotion from that date. Now, this is not a kind of panel from where appointments have to be made, which expires after 1 year or 2 years, depending upon what the executive decision is. Now, he was found fit to be promoted. He was not promoted because of this punishment. The punishment period was over.
Yes, lordship.
And thereafter, others also were punished. No. No. They were subjected to departmental proceeding. Were they punished?
My lord, that aspect I don't.
That you take that instruction tomorrow, day after tomorrow.
So,
That aspect I will take instruction.
yes.
They were punished.
So paragraph number 6, lordship.
उसको ज्यादा कर दिया वो सेट है that may have said. In the fruits of litigation, the appellant's father could not read. because this petition was, this was pending. And the reviewing authority did it only for him or for others also?
Only for me, Lordship. The review was dismissed, Lordship, by the Honorable Court. Initially.
Review is dismissed, we understand.
Yes.
I am talking about departmental reviewing committee.
Yes.
Did, I mean, they all six received similar punishment. And the reviewing authority enhanced the punishment only with respect to him or with others?
I have not.
You have no instructions. Take instructions and come back to us on the next. Take them. We will not give our introductory thing because it may bias the case of the petitioners, of the appellant. Mr. Sharma, what is his name?
DK Sharma.
No. Uska naam kya hai? Mr. DK Sharma, learned counsel for the respondent, seeks some time to take necessary instructions from the department regarding the status of the other 6 employees whose services also were terminated, but the termination order was set aside. And status. Re-notify. We'll keep it in January.
Yes. Mass of Lordship.
That's the only thing that you have to tell us.
28th January.
Yes.
Wait.
Mass of Lordship.
Item 32, 34 for hearing.
अरे मेरा notes अलग कर दिया. Today we are concluding it. जैसे रखा था जैसे मिला था कर दिया ना. जजमेंट कभी फाइल बना देना तो सैटरडे को हम लिख आएंगे. Yes.
Great pleasure, Lordship. Lordship has already gone through the facts as well as
Louder.
Yes. Great pleasure, Lordship. Lordship has already gone through the Lordship facts as well as the law points also, Lordship.
Yes.
Just I reply as indicated by Lordship some of the issues which is raised by the Lordship, appel and Lordship. The first issue is Lordship in respect of prosecution sanction, Lordship. I have given 2 compilation, Lordship. One is for judgment which I will be relied, and other thing is Lordship. The documents for this.
Yes.
So Lordship, prosecution sanction is the our compilation, Lordship, in page 1 and 3, Lordship. Page 1 to 3, Lordship. That compilation, Lordship, just I have given, Lordship.
It is 123. 1, 2, 3. Okay.
Lordship.
Yes.
This is the prosecution sanction issued by the authority, Lordship. And this was done as per, Lordship, the procedure prescribed in the law. So there is no violation of the timeline, Lordship, in respect of, Lordship, Rule 3 and 4 of 2008 rules, Lordship. It is within the time, Lordship. And in that respect, Lordship, the evidence is also there, Lordship. He is the PW 14, Lordship. PW 14 I have in the compilation page, Lordship, 73 to 74, Lordship. Lordship got it, Lordship? If Lordship, I permit, I can read the evidence part of the law.
Yes.
Here, Lordship, PW 14, Lordship. I have been working as Under Secretary so-and-so, Lordship, and I issued the order dated so-and-so on behalf of the Government of India for transferring the 4 cases, including case number so-and-so, registered in Dhekkiajuli PS to the NIA in accordance with.
That's all. He says that this letter
As
is
per,
sanctioned in the
as
ISO.
per procedure. So, Lordship, in that respect, I relied on latest judgment of the Honorable Appeals Court, Lordship, that what states, Lordship, they have challenged the prosecution sanction at that part and even timeline also, Lordship. It is in, Lordship, 2024 SCC online SC 2610 Lordship. Has that Lordship, that single page the judgment passed by delivered by my lord Lordship. That was I have given. That single, it is, I have
This judgment which you've given,
Lordship.
this was interfered with by the Supreme Court.
That part I have not gone to otherwise Lordship. On in regarding.
This was not on the issue of sanction.
No, Lordship. This is not in respect of sanction. This was.
I mean, I had granted bail to, I had refused bail to an accused.
Lordship. It is in respect.
Because this was an appeal.
Lordship,
So
this-
therefore it had come before me.
this is-
And
I just relied.
I sustained the order
Lordship.
of the NIA court.
Lordship. That particular judgment I will be relied in respect of the conspiracy part, Lordship, not the prosecution sanction part. Lordship. Conspiracy part, Lordship says detailed discussion is there. That's why I am bringing it, Lordship.
Yes.
Otherwise, Lordship, the prosecution sanction I am
In that case, just to quench your curiosity,
Lordship.
that was a case where the NIA had caught hold of sleeper cells.
Lordship.
And this man was a police officer.
Lordship.
And it was suspected that he was recruiting people
Lordship.
for ISI and all that.
Lordship.
So many things were recovered from his place.
Lordship.
Now, along with him, an advocate also was prosecuted
Lordship.
for being in collusion, being part of that entire team. But that advocate was arguing in different high courts
Lordship.
for people who were being made accused in this case.
Lordship.
So therefore, I granted him bail, but rejected the bail of the others. But that was interfered with.
But that my purpose is only in respect of Lordship, the disclosure as well as conspiracy part as well as terrorist act. This was discussed by the my lord had discussed
yes.
by discussing all the Supreme Court judgment. That's why I bring it, Lordship. So Lordship, in respect of prosecution sanction, I am relying Lordship 2024 SCC online SC 2610 Lordship. First judgment of the compilation Lordship. Here I am relying paragraph 15 to 18 Lordship.
15 to 18.
15 to 18 Lordship. 15 to 18 is Lordship in respect of Lordship. What is this Lordship? They can challenge the validity of the sanction Lordship. Just I point out the Lordship paragraph Lordship, then I will conclude on part Lordship. 15 to 18 Lordship. Then Lordship, timeline part was discussed in the judgment in paragraph 19 to 33 Lordship. 19 to 33 Lordship. Then my lord may kindly come to paragraph 33 Lordship. It is an internal page Lordship. 30 Lordship, 30 Lordship. 30 Lordship. Last 4 lines I have read it Lordship. It starts from Lordship, the legislative intent Lordship. And this case is Lordship is it relates to the UFP Act Lordship, especially Lordship. The legislative intent is clear. Rules made by virtue of the statutory power prescribe both a mandate